The scales are rusted, they tip and they sway. The sword's been dulled, it's been locked away. The blindfold slips, revealing the game. Lady Justice, tell me, who do we blame? This isn't balanced, this isn't right. We stole the stars from the flag tonight. Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? The gavel falls, but it don't make a dent. The halls of power feel broken and bent. Promises whisper and swept with the breeze. Truth gets tangled in the webs of greed. Blindfold torn and the swords in the dirt. The scales can't hold the weight of the herd. Oh, tell me, where did you go, Lady Justice? We need you so. Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? Lady Justice, where are you now? We're screaming loud, but you don't hear a sound. This isn't the America I knew. Lady Justice, where are you? Lady Justice, where are you now? We're screaming.
Hello? How's everyone doing? Hey, Mustang. How's it going? Hope all is well. Hey, Unindicted. Good to see you. So I'm just going to go ahead and get started. I looked into this, like the record process and the filings and all that in the Delphi case. And it just seems to be a consistent, like, chaos. I didn't even remember half of the things that happened when it came to, pleadings and motions and all that stuff, and all the records that were, sealed and then marked confidential, and then the whole original action in the Supreme Court. And here we are, exactly 1 year later. Trial was going on 1 year ago, and we're still not getting access to court documents. And when I say documents, I also am including, like, files, right? So videos, pictures, all that. So I went through Indiana's public access law and also Indiana Code, which is kind of one and the same, right? And looked at which records are excluded by law, right? And records can be excluded from a federal level and also a state level. Okay, so I think that's important to point out. So there's some records that, just because they're this, this type of record, it's automatically excluded, right? And then we have records that you would exclude when you file, whether it's exhibits or motions. When you file it, you have to mark it confidential. But guess what, everyone? Just because you decide it needs to be confidential does not mean that it meets the scope of an excluded record, right? So I thought it would be a good idea to just kind of go over what is in scope from, records that are excluded, and what is the process to, I guess, really, I don't want to say the word appeal, right? Because that's, I guess you would be appealing a decision, but to file complaint, okay? So I'm going to go ahead and get started. I'm going to share my screen. So I think probably just start with what records are excluded from public access, right? So this is Rule 5 pertaining to Indiana. And I do want to have an disclaimer. I am not an attorney. This is not legal advice, obviously, because I don't have a license to practice law. So this is just, I'm just going over what is accessible to everyone, right? So we're just going to review it. So Rule 5A, okay? These are court records that should be excluded from public access in its entirety. So essentially, this is what I said, like that one bucket, right? So the first one here is entire cases where all court records are declared confidential by statute or other court rule. Now, I want to point something out here. You know, each county in Indiana has their own court rules. You know, they have to follow, I think, like a general rule, like all the rules that are out there and, you know, that's in code, right? But they cannot make a rule that overrides the public's right to access, to inspect and access records. Okay, so that's important to point out. A2 are entire cases where all court records are sealed in accordance to the Access to Public Records Act. Okay. And then 3, entire cases where all court records are excluded from public access by specific court order entered in accordance to Rule 6. Now, Rule 6, pulling up my notes here, are extra, oh my God, I can't speak right now, extraordinary circumstances, okay? So this would be, I guess like an example of this would be a probable cause affidavit before the person is like arrested. Well, that doesn't make sense. Like a warrant, right? Like I can see why they would want to, you know, seal certain documents because it has not yet, you know, been brought to court. You know, there might be a subpoena or something like that. But that Rule 6 is the presumption of openness and requires compelling evidence to overcome this presumption, as well as a public notice, a public hearing, and a written order containing specific findings. Okay, so a caveat to this rule, based on my research, is that this rule is not retroactive. So it specifically states, while a request made under Rule 6 treats the court record as confidential from the time of filing or tendering until the court rules on the request. Okay. Moving on, all mental health cases. So that is excluded. That's like a medical record. Here we go. Entire cases when it comes to like investigative requests and process related to a pending criminal proceeding. So actually, that is so that's a separate rule. So I gave an example that is not Rule 6. So I apologize. So Rule 5A Where am I? So Rule 5A5, that's where, like I said, it comes to like a pending criminal proceeding. Okay. Moving on, all paternity records created after July 1st. And then if court ordered an entire case, the clerk of court has opened under the wrong case type. This is kind of funny because I was going through, what is it, Indiana.gov for like the case file, like, court cases or whatever it's called. And I saw a case file where it was accidentally opened, under the wrong person, a wrong file. And it had like this long explanation. I wish I remember what it was, but it was, I did it again, something on the nature of like, I did it again. I accidentally opened this, or entered this file in the wrong case, something like that. And I thought it was hilarious because after reviewing what the actual like requirements are and the scope for this, Rule 5A7, that is not what that is. So, okay, moving on. 5B, this is where, from my perspective, like, this is where their individual case records. So within a case, the records, right? So this is where we're seeing a lot of the confidential filings in the Delphi case. So 5B1 is case records declared confidential or excluded from public access pursuant to federal law. Okay, so there's another list, right? If it's on a federal list that is excluded from public access, it would meet the scope right here. Well, one of those things is actually 5A5. Some of the things in 5A5, which would be investigated, but this would be like FBI records from how I perceive the language here. And then B2, this would be, it's excluded from public access or declared confidential by Indiana state or other court rule. And I'll go through that in just a moment. And then checking my notes real here. So where was I at? Sorry. Okay, I'm going to jump to B4. This is case records sealed in accordance with the Access to Public Records Act. So there's another list, right? There's a list based on Indiana law, which is it's coming from like FOIA in a way. That makes sense. So like FOIA is driving the public access law. So there's a lot of overlap here. Then we go into statutory or common law privilege has been asserted. I'm thinking that is something like attorney-client privilege. So then we go to 6. This is like the problem solving. So I think this is I believe this is like probation and stuff like that. I'm not positive. We're not like, I don't even know if I should go through all of this because like a lot of these are not applicable. But we have more mental health records that is also on the list. So you got treatment purposes, medical service providers and examiners. Okay, I'm going to move to 11. Okay. This is very interesting after I read this. So it says photographs, film, video, recordings, or similar mediums showing a live individual's uncovered genitals, pubic area, buttocks, or female post can't read this. I think it's like the nipple. YouTube's going to hate me after this. And then we got photographs, films, video recordings, and other similar mediums showing a live individual engaging in or being subject to sexual conduct, right? And then we have guardian ad litem, court appointed special advocate report. So that is also excluded from a public record. But again, moving back to 11 and 12, and please, like everyone, I'm not here to provide a position on this. Okay, I'm just here going over what is excluded from public access, right? Just like I said. So what stuck out to me is that these are live individuals. Okay. Okay. I think we're seeing some of the, so 5C here, we're seeing some of this in play. And I think that is one of the reasons why we have redacted records. This is personal information of litigants, witnesses, and children. So 5C1 allows a party or person to redact social security numbers, account numbers, personal identification numbers, and passwords without filing a separate written notice of exclusion, as long as the court does not need the information to dispose of the case. Okay? So you can, how I read this is you can, if there is a witness or child, and I'm going to go into the child thing in a minute, but you're to, redact the, social security numbers, or, if there's like checking account information or passwords, like that is excluded, but the attorney is allowed to redact that on their own, right? They don't, like, it's the whole record is not excluded. That's how I interpret this. And then so this rule 5C1 requires both a public access version and a non-public access version. And the party must file a public access version and so they have to file both of these. Like they have to redact it themselves. But here's the caveat to this. If a whole page is omitted, some type of notation should be made at the precise place in the public access version, indicating where the omission occurred. So if you're, I guess, if you are excluding a whole document and you're marking it, confidential, and you're redacting an entire page, you have to make some type of notation. That's the way I read this. And then you also have to put basically the grounds of which the exclusion is based. So the way I read this, so let's say in the Richard Allen case, actually we had this happen actually, where, Richard Allen's, I think his social security number appeared in one of the documents. And I seen at trial that I recall at trial, there was, maybe a sidebar or something where they had requested like this would be excluded. But by itself appears to be excluded. And then post-trial, there was some mention in one of Nick's motions to also exclude that information, like from an exhibit. I'm not sure if you still need to go through that process. Again, I'm not an attorney, but the way I read this just looks like you would automatically redact that information and it doesn't require approval. So again, like 5C is personal information. And then there is, so 5C2 states like this is more specific to cases of sex offenses where the names of child witnesses would be excluded from public access, which totally makes sense. Should be. 5C2 also allows a party or person to replace the name of the child witness without a written notice of exclusion, without filing a written notice of exclusion. 5B3, and I hope you guys can see the screen because it's really tiny on my end. There is a notation that I've seen that juvenile refers to juvenile delinquency status and miscellaneous case types. So I don't think, I'm not sure about this one, but it appears like this is, other type of cases where you would redact. I'm not sure. But there is a provision addressing, witnesses and children. And then it says court administrative records that must be excluded from public access. So it says the following administrative records are confidential and must be excluded from public access. So it says case records excluded in 5C, court administrative records excluded from public access or declared confidential by Indiana statute or other court rule. Like this is kind of repetitive here, but it also does speak to attorney, their addresses, emails, except for administrative purposes, and also judges, so judicial officers, so clerks and other employees of court, and clerk of court, unless that person or persons about whom the information pertains to waives confidentiality. And then, now this is really interesting here. So D5 says all personal notes, organizers or calendars, electronic communications, including without limitation, email, text messages, photographs, and all related electronic data and deliberative material of judges, jurors, court staff, and judicial agencies, whether recorded electronically or on paper. Okay, and then it also, so then 5E goes into detail as far as like what it, these are records that would be excluded on a temporarily basis. So here's that example of like that warrant in 5E1A. And then it does have a procedure here as to, the following shall be excluded from public access by filing the document or green paper. Okay, so my understanding of this is when, this kind of like instructions to the clerk, maybe like, I seen like some language about green and white paper. So like, let's say something's excluded, right? It like there has to be two versions of it. So you need like essentially kind of what I went through already. There's a process within that, if so. Now I'm moving on here. Okay. I know I'm not going like, I'm going to be going back and forth a little bit here. So here's the procedures for excluding exhibits and testimony from public access. So 7A exhibits, a court record tendered or admitted into evidence during a hearing, trial, or an in-camera review that is to be excluded from public access shall be accompanied by a separate written notice identifying the specific Rule 5 grounds upon which exclusion is based. And it's interesting because I'm going to go into this a little bit later, but when a clerk or whoever, court reporter, whatever, denies a record request, they are supposed to provide the specific rule as to why you cannot get that document or file. Okay? So I'm seeing a lot of feedback, in different social media platforms that, people are not getting a reason, or at least not the legal reason as to why the record is excluded. But they're required to give that to you. Now, I want to go now to kind of what we've seen in this case. Oh, gosh. All right, I'm going to start here with, I think this all starts at the gag order. I think that's this. No. So we had so this is 11/14. This is before the gag order. Let's see. This is December 2nd. I think this is where it starts here. So Nick McClellan filed a request to make the gag the press, essentially included family members and the coroner, which I think like autopsy records are automatically excluded. But at least, like personnel, officials and all that, to prevent them from making public communications. Okay. So that he filed that, I want to say in November. And then the attorneys for Richard Allen went out and did a press release. And Judge Gull issued this order. Basically, like I said, barring people from talking about this case to the media in public, directly or indirectly. And then in here it says counsel are reminded that they are required to conform with the Indiana rules of court, rules of professional conduct, specifically Rule 3.6. Okay, I have 3.6 here too if you want to look at it, but I don't want to put everyone to sleep. And then it says here violations of this order are punishable by as contempt of court and subject to that violator to a fine and other incarceration. Okay. Now, I don't know if you all remembered how everything was sealed in the very beginning. So everything was sealed, and Nick wanted to keep the information sealed. And actually, that's not this order. What is this? Sorry, everyone. Just trying to. Yeah, this was like all chaos, everyone. I'm sorry. Trying to find the actual date, but I don't have it right handy right now. But at any rate, Judge Gull, everyone wanted the PCA to be unsealed, right? And Nick McClelland's position it was an ongoing investigation. So, did you see how there was an exemption? I cover that. Certain investigative reports could be excluded. So I think that's why he played that angle. Like, we don't, we're still investigating. We think there's other actors involved. Or they may have, Holman said that they believe that Keegan Kline was involved. So I could see some merit to that. But at any rate, they filed it, wanted to keep it, and Judge Gull basically unsealed the documents. Okay. I don't know why I can't find this. Sorry, I'm flipping around. Okay, here it is. I found it. All right, so this occurred on November 28th. Okay. And Judge Gull said the court, having had this matter, this is so small, under advisement following a hearing conducted on November 22nd, 2022, and having considered the evidence submitted and the arguments of counsel, now denies the state verified request to prohibit public access to a court record in part, right? So meaning, some things are still going to remain confidential. That's how I interpret that. The court finds that the state has failed to prove by clear and convincing evidence that the affidavit of probable cause and the charging informations should be excluded from public access. Remember, extraordinary circumstances, right? This is not extraordinary circumstances, what Nick was asking. All right. The court finds that the public interest is not served by prohibiting access and that the protection and safety of witnesses can be ensured by redacting their names from the affidavit, which we just went over. Is like, he didn't have to go this route, in my opinion. He could have, made 2 copies, one for the public, one for, the clerk or whatever, by modifying the names, or redacting them or using initials, right? So like, he didn't have to go through that. So that argument was not according to what is allowed by law, in my opinion. Again, not an attorney, just giving you my personal perspective on this. So I'm going to continue on. And that the protection and safety of witnesses can be ensured by redacting their names from the affidavit, and the defendant's personal information can be removed from the charging information, right? So that's also in the exclusion list that we just went over, like private information or personal information. The court notes the prosecuting attorney submitted charging information in a probable cause affidavit at the November 22nd, 2022 hearing that was redacted, eliminating the witnesses' names and identifying personal information of the defendant. Good. That's what you're supposed to do. Those documents will be released to the public and made part of the record of this cause. The original charging information affidavit of probable cause shall remain as sealed and confidential court records as they are not redacted. Okay. And then there was also another motion, people requesting these documents. So now she's saying it's mute because like she's releasing it. Court orders that the redacted charging information affidavit for probable cause submitted by the state at the hearing on November 22nd and filed with the clerk of the court with this order, and further that the clerk shall not release the original sealed unredacted information and affidavit, which is really interesting because I have a copy of the unredacted, at least the search warrant So how did, you know what I'm saying? Anyhow, moving on. So now we will go to I'm probably going to be jumping around here. I'm going to go here. So this is the response to the writ of mandamus. Essentially, here, this is funny, actually, when I was looking through this. So I don't know if you remember, there was 118 documents that still were not released. And I believe this is the Franks motion, if I'm not mistaken. Yeah. 1 second. Okay. So in this ruling, I guess you could call it, is again, like they're reiterating the need to, or the importance of public access to court records. Like you can't just go in and not provide the public access to court records without, essentially going through the procedure and the process. Okay. So if I recall this correctly, Gull issued something where she already began to make accessible these documents. I think that she used like her the Allen County website to release them, but they still were not on file. They weren't in the CCS. Okay. And then they reiterated, we now take this opportunity to clarify the requirements in our ACR rules, which recognizes the strong societal reason for allowing public access to court records. And she's saying, like, the ACR rules presume that public will have open access to court records with limited exemptions. Those exemptions are found in Rule 5. We just went over Rule 5, right? And 5A sets out several categories of entire cases excluded from public access by statute, and they're to be treated confidential. 5B sets out 13 types of individual case records excluded from public access. And then she's saying, aside from those two exceptions, Rule 6 permits a trial court to exclude otherwise public court records from public access only in extraordinary circumstances and by following the rule process. That process requires any person affected by the release of the court record to make a written request to prohibit public access, which must give notice to the parties and allow them 20 days to respond. And before a trial court excludes the request record, it must hold a public hearing and issue a written order explaining why it is granted the request. ACR Rules 6C through D. We expect the Indiana courts to comply with these rules. Okay. I hope I find this. No, not that one. Sorry. So Gull is this it? I think this is the one. On 11/14/23, says the court has recently reviewed the CCS in this cause and notes that the clerk of court has not yet made available to the public on the CCS the 118 documents previously made remotely accessible by court order on June 28, 2023. The court previously created a website for these documents as a convenience to the public and the clerk, and to ensure the public had prompt remote access to these documents. Okay, the clerk is ordered to enter these documents on the CCS forthwith. The clerk is further ordered to unseal the June 20, 2023 filing by the Carroll County Sheriff and the July 5th, 2023 letter from a Department of Correction inmate. So this is the the Bass, what was his name? Baston? That was marked like confidential, or it wasn't, people couldn't see it. The court further notes that a motion for Frank's hearing, so that's the September 18, 2023, including the Frank's motion memorandum in support of motion exhibits list, are marked as confidential on the CCS as counsel failed to supply a redacted version at the time of filing. Okay, so this Frank's motion is huge. It's like many pages. I don't know what reason it would need to be confidential. I'm just talking about the motion itself. I'm not talking about, what was within the exhibit. I'm talking about the motion. I didn't see any juvenile witnesses' full names in there. That's weird. I'm going to check in with chat. I'm so sorry. I don't mean to abandon everyone. Hey, John Paul Hansen. Am I putting y'all to sleep yet? Hi, Jindy. Unindicted says she must have been mad at Nick that day. Yeah, I think so. I'm going to close my door. I might have that open. Here's the Administrative Rule 9G5, Notice of Exclusion of Confidential Information from Public Access. This is interesting also because this is post Richard Allen's conviction, I believe. So they're applying this Administrative Rule 9G, right? 9G has been repealed since 2020. And it was replaced by Rule 5. So like what we just went over. I don't know if this is like a big deal, but just something I noticed. All right. So I think there's a misconception as to who can request records. Like, all persons have access to court records. So you don't have to be an Indiana resident to request a record. Like, you have, based how I read this, you have the same access as everyone else except who is in subsection B. And in subsection B, this is just talking about, who takes priority or who has greater access to court records. And that's like the court and their employees, private or governmental persons or entities, public agencies, the parties to a case. so they would take priority over, anyone else. And prospective lawyers in juvenile paternity cases. So, and then here, there's a commentary here. Section A provides the general rule that all persons, including members of the general public, the media, and commercial and non-commercial entities, are entitled to the same basic level of access to court records. Access to court records is not determined by who is seeking access or the purpose of seeking access. Don't you find that's interesting, right? Like media, I don't think, the way I read this, I think they're like considered public, but I don't know. I'm going to read on. Although some users, such as court employees or the parties to a particular case and their lawyers, may have greater access to those particular records than is afforded to the general public. So, and then also subsection B provides the exemption to the general rule and specifies that entities and persons for whom courts may provide greater access for effective management of the judicial system and the protection of the right to a fair trial. Okay. So now I kind of pretty much put like some of the fundamentals here. This order here, so now we're in June of 2023. Okay. So a little bit closer to where we are now. And we are they're still having issues with the pleadings and filings being marked or as sealed or confidential. Now that what I found interesting here in this order says, this is second paragraph. Counsel agree with the court that the public interest is best served by transparency, but the certain pleadings should remain, but that certain pleadings should remain sealed. Okay. Counsel agree that the original unredacted affidavit for probable cause shall remain sealed as it lists names of juvenile witnesses. That the transport orders previously entered and future ones shall remain sealed for security purposes. And then defense ex parte motions are related orders shall remain sealed. All other pleadings filed prior to the date of this order shall be unsealed and available to the public except for pleadings explicitly mentioned in this paragraph. Future pleadings and filings that are to be confidential shall comply with court rules. So I found something that basically stated, going back to my notes, sorry for my dogs, if you hear them in the background. That you can't circumvent ACR just because you agree on something. The way I interpret this is Judge Gull can't call all the attorneys together and be like, hey, we are going to seal the bridge guy video should not be released. And let's say Baldwin and Razi say, okay, we agree. No, that is not just because people agree does not mean that it is correct. Does that make sense? So I don't know why she put counsel agree with the court that public interest is best served by transparency, but that certain pleadings should remain sealed. No, yeah, that's a violation, of public access laws. Does it matter what, like, I know I keep on saying the same thing over, but does it matter what they all say or think or agree on? Does it make it right? So I'm still like wondering why certain exhibits and photos and all that are not accessible to the public. I guess that's where I'm going with this. That is crazy to me. Because again, let's just take the bridge guy video, okay? Does it meet an exemption here? I mean, unless, I don't know, because there is like a blurred out spot that always been bothering me on Bridge Guy. It's like by his pocket. I don't know. Is he exposing himself? I don't know. I can't see what it is, but unless it's that, I don't see why that the Bridge Guy, and I know that there's a Bridge Guy video out there. Okay, I get it. It's out there, but there's different versions of this video, right? We got like a enhanced one, we got the original, we got I don't know, just it's like I think there's 3 or 2 versions of this out there. So I don't know. What do y'all think? Am I misreading this? Unindicted says, does not matter who or why. Good to know. Yeah. All right. Moving on. So I have here just like kind of what on a federal level, what is excluded, because you may want to ask, maybe this is something that's excluded from the federal level, right? Because that is an exemption. I keep on saying exemption, but that's the way I put it in my mind. Or exclusion. Actually, that's a better term. It says exclusion right here. So, okay. And this is an awesome document. Just, it does have like court cases in here. So C1 is whether a request is made which involves access to records described in B7A and A, the investigation or proceeding involves a possible violation of criminal law. So this is federal again. And B, there is a reason to believe that this I, the subject of the investigation or proceeding, is not aware. So like this is kind of like redundant. You know what I'm saying? Because we kind of like covered that. So it can't be that, in my opinion. And then C2, whether informant records maintained by a criminal law enforcement agency under an informant's name or personal identifier are requested by a third party according to the informant's name and personal identifier. The agency may treat the records as not subject to the requirements of FOIA unless the informant status as an informant has been officially confirmed. Okay, so that's an option. And then C3, exclusion pertains only to certain law enforcement records that are maintained by the FBI. Okay, so we kind of seen some of that in this case, right? There was supposed to be an expert that was going to testify pertaining to, more specifically to Brad Weber, as to what time he got home that day, because he allegedly, based on the state's theory, on his own testimony, he arrived home at 2:30, which I covered in my last live stream, that Holman testified that he believed that he did not arrive at 2:30. So there's that. Now, this is an awesome, awesome handbook on Indiana public access laws. And this is the Office of the Public Access Counselor. So it kind of goes into, so the public access law is it's more than just records. It's also like access to government like meetings, let's say. Whether it's a town or council meeting or a commissioner's meeting or the budget, like things like that. I mean, I know it's more to that, but I'm not going to go into all of that because like it's not really applicable in this case. And then here it says section 3 is a overview of the Access to Public Records Act. But it's pretty long and it's really well put together. So it defines what a public agency is, which also includes our judicial courts. And it has examples in here too. So one thing that I learned by looking at this is that certain emails and phone records is a public record, like as long as it's not excluded, right? So like the public meetings, let's say, also like they don't have to provide like a transcript of the meeting, but they have to provide like the agenda to that meeting, and it needs to be posted during a certain timeline. Interesting enough, there was a lot of public access counselors' opinion on Carroll County with violating this, but that's a whole nother topic, like I said. So I'm just going to go through here. I mean, there's a lot of requirements, the open door policy. Okay, let me get to the records. So public agency, very broadly, so it's defined as boards, commissioners, departments, or commissions, departments, divisions, bureaus, committees, agencies, and offices exercising administrative, judicial, or legislative power. Counties, townships, cities, towns, law enforcement agencies, I'm not going to go through all this, but it is in the scope of the Public Records Act. Okay, so courts are in this act. Just want to say, and then here it does, go through what it may be made confidential by state statute. So we got juvenile law enforcement records, court records, protective orders. So that we saw that in this case, I believe that's the gag order. I think I have to look at that statute, but maybe not. Confidential motor vehicle records, victim addresses, school records, patient treatment records, like we covered that, TANF records. Okay, here we go. This records made confidential by federal law, FERPA. Yeah, like this is all like stuff. It's kind of redundant. But there's some more there. Okay, a photograph, a video recording, or an audio recording of an autopsy. That's automatically excluded. Okay, Here I have like information as to, you know, being required, like it's a certain timeline after, like the government in Indiana needs to, you know, post somebody's identity. Like we saw that in this case too, because they withheld Richard Allen's information and where he was being held from the public until they had their own press release. But yeah, there's examples in here. I'm not going to go through all of this. Here, a public record means any writing, paper, report, study, map, photograph, book, card, tape recording, or other material that is created, received, retained, maintained, or filed by or with a public agency. So that includes media, audio, right? But what I wanted to show here is, okay, if you request a record, there's a, you know, by statute, how much it's supposed to cost. That's in here. Okay, denial of disclosure, okay? This is where I was saying how they have to provide the reason why something is being denied. So right here, look at this. I know you can't see my pointer. So I'm going all the way to upper right here. A statement of the specific exemption or exemptions authorizing the withholding of all or part of a public record. Now, there's a timeline in here too. So if you request a public record, so this would be like you request it from a public agency, like the record keeper, right? Whoever is responsible for records. Depending on the agency, you know, that could be, you know, the clerk. I don't know. Or like, let's say you're requesting a police report, right? That would be, you know, you would go to the police station and be like, hey, I want a public record. Who, you know, who handles this, whatever. So there's a timeline here. Okay. So 24 hours. Since the person designated by the public agency as being responsible for public records release decisions refuses to permit inspection and copying of a public record when a request has been made. Now, if you request it by mail or fax, or let's say email, denial of disclosure does not occur within 7 days. There's like certain ways to like I said, file a complaint. The public agency meets its burden of proof if it's an exempted record. And then anyway, this has here, so Appendix A is helpful. This is like when you want to make a complaint to, you know, the Office of the Public Access Counselor. Now there's a timeline. You have 30 days. So if you get a denial, let's say you're asking one for state of Indiana versus Richard Allen, and you ask for a record and they deny it, you have 30 days, okay, to file complaint. And when they say inspect a record, this means like getting a copy of a record. It's one and the same. And then here is a checklist for agencies responding to requests for access So this is their guidance, but it's saying, hey, if the request was made orally or a written request was hand delivered, the public agency must respond within 24 business hours. Okay. If you send the request like by mail or email, the public agency must respond within 7 calendar days. Now, when I say respond, it doesn't mean a decision. Okay, it's just like, hey, I received your request. Okay, and I put this on my YouTube community as a post here. I did not write this, unindicted. If you're still here, this was something that I just pulled from the public access counselor, who there's a new counselor now. It used to be, what's his name? Brett. I talked to him once. He was really nice. But anyway, here's a sample letter of like, hey, I would like to inspect or obtain a copy of the following public records. And then this is really important. Really, really important. Your request can't be too broad. You can't go there and say, hey, I want, like, say if I want to go to my town that I live in and want to know how many, I don't know, claims have been made against the town. And I want to get this from 2022 to 2025. That could be perceived as too broad, and they can deny it because of that. So you have to be very specific. You have to say, hey, I'm looking for like how many fires occurred at this address, or you know what I mean, something like that. Or like if you're looking for a police report, generally speaking, you need like the party, like the person's name that you're looking for, as specific as you can. So, but also there's opinions out there that I read where that, the government tried to go that route, saying, no, your request is too broad. And there was pushback, like, no, that is not a, broad request. You should be able to look this up. So it all depends, but I'm just saying be as specific as possible. So I think that's kind of the angle that Jody was going when she was denying, because people didn't have exhibit numbers. But I'm pretty sure, like, this is just my opinion on other opinions that I read. If somebody, like, if you know what day and time, like, hey, October, 29th, I want, all the exhibits entered. Like, that is not hard to locate. You know what I'm saying? So I don't know. I feel like if somebody would have made a complaint, it might have gone fair for the, the complainant. So that's that. Here's some more records, access restricted. Kind of like what we kind of went through already. Okay, so they do have records specifically required to be disclosed. Okay. In here, it says information required to be disclosed by a coroner regarding the investigation of a death. Like, that's on this list. And then here, how do you file a complaint? It's in there. Responding to a formal complaint. Contact information from the public for the public access counselor. Here's the phone number. Again, you do not have to be a resident of Indiana to file a complaint or to request a record. You have the same rights as anyone else, except if, well, I guess you have the same rights as everyone else, but you may have a different priority, if that makes sense. All right, what else? Okay, another resource here. So the Indiana Supreme Court has a handbook here. Goes into, detail. Okay, here's where it says, remember I said like that Rule 9 was moved to like Rule 5? Or like they're like it was revamped. So right here it's saying admin Rule 9 has largely been removed and placed in the access to court records rule in accordance with the conversion table below. So here's just more information. You can get this if you go to www.in.gov /courts and get there somewhere. It's on there. So like, I guess, okay, here's an example right here. I don't know what this was attached to tell you the truth. So here's a message from Jody to a Justin, is it Balding, who made a request. See how she acknowledged receipt? So when did he send it? I don't know. I have it. But anyway, let's see. So Jody's the custodian of records. January 8th. Okay, they even put the code in there. That's awesome. Okay. Here's the case number. They requested any and all recorded police interviews with Richard Allen, any and all recorded prison phone calls between Richard Allen, his wife, and his mother. Okay, so her response says, "Good afternoon. I am in receipt of your request for release of exhibits. Perhaps at some point in the future, media may be permitted to view the exhibits that are not sealed and confidential pursuant to Indiana's rules of public access or court order at a time and date the court determines, but it would be after the filing of the transcript with the Indiana Court of Appeals, as the exhibits are required for that purpose." Okay. But like, I don't understand, like, I don't interpret the media, like they were not in that priority category. Like, should we look at that again? Because let's say, where is it? Here are the persons for Rule 2B are the ones that have greater access to court records. I don't see media in here. But anyway. I do believe I did see something somewhere, like maybe in an FAQ, where there is like, actually, this makes sense. So she's saying like the filing of the transcript needs to be made. Like that is on the list who has greater priority, right? So that's what she's doing. You know what I'm saying? So that does make sense. But like here, according to, the Public Records Act, she is supposed to deny and provide the specific reason why this person, Mr. Balding, was refused the exhibits. And I don't understand why these exhibits were marked confidential. I don't know. Perhaps maybe the gag order has something. No, but like, because it is media, but still, I don't understand. And then when a case is completed, does it automatic, like who's responsible to mark those exhibits from confidential to public? You know what I mean? I don't know, but I do know I read something that if it is confidential and it goes over to the appellate team, like that carries over, is my understanding. Mm. Hey, Michael. Waiting to see if I'm denied contempt exhibits, even though I was counsel of record in the contempt proceedings. I mean, I wouldn't hold your breath there. That's crazy. I don't know, Michael. Thank you for being in here. I'm just curious. Am I interpreting this correctly as far as, what is excluded? Am I missing something? Because like to me, like, and technically speaking, the way I interpret these is, people might get all pissed off or whatever, but like, I don't see crime scene photos to be just a reason for exhibits to be excluded. I could see autopsy, right? It's like on the list of excluded. Oh, you don't know? Okay, that's fair. No, I just like in general, like being people, numerous people being denied access to records. The way I interpret it, if it's not on the Rule 5, or in the public access laws, or excluded by federal, you know, whatever's in the federal statute, that it is accessible. And I like, for example, like the bridge guy video. I know that there we have access to that. But like there's 3 different videos. You know what I mean? Or 2 or 3 different videos. And I don't understand why the video would be excluded other than it being marked confidential for whatever reason. And Jody's just looking at it and it's like, okay, it's marked confidential, but not applying the actual law. Not in the ACR rules. Pics of dead bodies are not excluded, right? 5B11. Thank you. So 5B. Yeah, that's what I was saying, because they're not live. And then photographs, film, video recordings, or other similar mediums showing a live individual engaging in or being subjected to sexual conduct. I don't know. Like, are they excluding it because, like, does he have his thing hanging out? I don't know. Like, I know there's a little blurry spot that I've been like trying to figure out what the hell that is for all these years. I don't know. Hi, Hebe. Yeah, I'm not an expert either. I was just like combing through this. Like I have been a custodian of records, but not in like the government. But I'm just not understanding why, like, for example, there's like in here it says that the clerk has to provide the reason, like the statute why it is excluded. So I just went through, I think you were here, but like in this example right here, I don't see the statute that excludes Mr. Balding from obtaining the actual what he's asking for. So yeah. Um so I think if we follow this guidance here with public, filing something with the Indiana Public Access Counselor, like they may agree or may not agree, but like it gives, I guess, maybe standing, maybe that's a wrong term, but it looks like you have to go through this process. And then if they're, still denying you access to records or denying not providing you with the reason it's excluded, or if they're redacting the document or record without providing you everything else, and then providing you the reason why it's redacted, then they're violating public access. And it looks like you can sue or file a claim. I don't know how that would look like. And if you win, they're required to pay your attorney fees. That's the way I read the statute. Like, for example, we have this Cecil report that has missing pages. So that's the Excel file of all the phone data. And there's like 2 or 3 pages that says, I don't know the exact term, but restricted from public access or excluded or whatever. And I was thinking, okay, could this be because it's a juvenile witness? And then the information of that witness, like phone numbers or full name, is in there. But then when I look at it too, I'm seeing that it's just it's like in certain cases. It's not every juvenile or well, maybe I'm wrong there. But it's like if it's a regular witness, it can't just here, let's go to it. I'm just going to look at it one more time. So that would be 5C. So if it had like your social security number of living persons and account numbers, personal identification numbers, and password, it's excluded. And then here it says the names of child witnesses in cases involving sex offenses, like that's not this. And then if we go to 3, it says addresses, mail or email, dates of birth, and phone numbers of natural persons who are witnesses or victims in criminal, juvenile, or civil protection order proceedings. Like that is not this anymore. Hey, Fish. Yeah, so I did that right here. I have let's see. No, not this one. I have so many files that I uploaded trying to be proactive, and it just seems like I caused more problems. Oh, I want to go back to this actually. Where is it? Mm-hmm. Nope. Here we go. But like this one, it's just interesting how that she blamed the defense attorneys for filing the Franks without, redactions, but I don't see anything in there that would need to be redacted according to what is supposed to be excluded. So 5A sets out several categories of entire cases. That's no longer applicable, in my opinion. But I could be wrong. And then second 5B sets out 13 types of an individual case records excluded from public access. The records falling under this rule, documents must be filed as confidential, included an ACR form identifying the specific basis for exclusion. So that makes sense. Like, it's like, have it a clean record in and out, right? So let's see. Let me check in here. Oh, hi, Shibby. Shibbers. I didn't see ya. Thanks for joining. Oh, that's a good point here. It's easy to be transparent knowing you won't be held accountable. That's kind of like very opposite things, in my opinion. So yeah, I think I have that here too. That's the procedures for excluding exhibits. And then, yeah, but I don't know. I can see what you're saying, because if it's marked confidential, like, who is the one to mark it public or whatever you want, not confidential? So then it could be released. Like, I don't know, like, who is the one that switches everything over after the case is over with? And does it carry over to the appeal level? I think it does. But okay, so going back to this one. Okay, so this is the motion that Nick filed shortly after. So he includes here the autopsy exception. That's already there by, like, it's automatic. Like, I don't even, anyway. And then he puts here, okay, in 1, that during the course of the trial in the above referenced cause number, both the defense and the state submitted several exhibits that include pictures from the crime scenes of the unaliving, pictures of the autopsies, and several mental health and medical records of the defendant. So, like, while the autopsy is already excluded, the crime scene, like, what does he consider the crime scene? Are they lumping the bridge into the crime scene? I don't know. Especially from a felony murder perspective, that's to me where that crime scene started, but it's not, crime scene pictures are not excluded. So I don't understand why this seems to be granted. Okay, and then like 7, that the courts are permitted to seal public records that fall within the mandatory exception of Indiana Access to Public Records Act without conducting a hearing. Well, that's only certain records. The way I interpret that, like, it was on the note, like the list. There's certain things that are on the list that are automatically excluded. Then yeah, no, you don't have to have a hearing. He is right about that, but that doesn't mean that everything that he's asking falls in that number 7 bucket. So let's see what else. I think I already did that once. Yeah, there's a lot because we can. I don't know if you caught this too, Michael, but I was saying that it's my interpretation that judges and attorneys can't just come up with an agreement saying, okay, we agree to exclude X, Y, and Z when X, Y, and Z are not on the exemption list or exclusion list. Like they can't make their own rules. And then local rules cannot override this Public Access Records Act either. So in my opinion, the Public Records Act trumps all of that, you know? And that's what I found interesting in one of Gull's orders. She said that the attorneys and the judge agree that certain things should be kept confidential. Well, just because they agree doesn't mean like it's I don't know, legal or allowed. Yeah, the Excel thing is cherry picked. Lots more in the actual phone data. I agree. It's like, but I don't know. I don't know that part. Yeah, so I have that Frank's memo exhibit that I was looking at, and there were some things on there that were marked confidential by Baldwin. And pull it up. I have to remove something else from here before it will allow me. I exceeded my 10. Here we go. Okay, here we go. It's uploading. So this is some of them. Like confidential photo of F on tree. Now, this one has been released, I believe. So that kind of goes with my thought that somebody moves them from confident. Well, actually, didn't the Supreme Court say that these all have to be public? I think she did, or they did. But like I wonder if this is like if it's not clean in. Let's say the error is made at this level, right? How does that get corrected? Like, who is the one to correct it and put it from confidential to not confidential? You know what I mean? And I'm not saying he erred. I don't know. Like based on how I interpret it, I don't think it's right, but I don't know. Oh, here we go. If you're filing confidentially, rightly or wrong, you need to put a notice of doing that on the docket. Then each doc has to have an ACR form attached. Is that the green bar? I wish I could make it bigger, Shibby. But I had them all like uploaded. See, I only could shift it around to make it smaller. Hey, Louise. Good to see you. Transparency ain't all it's cracked up to be. Yeah, transparency is even if it's something that is not what I'm looking for, desirable, it's still so important. Are you having a hard time too? Oh, sorry. The report that the coroner's report, I believe, is accessible automatically. Oh, wait. So Mustang says, I don't think transparency should include crime scenes of victim bodies, especially children. Hmm. Yeah, I don't know. I don't know what I would do in that situation as a parent, to tell you the truth. I think I've talked about this before. Like, part of me would not want my children to be out there. And then the other part of me thinks that this is, as ugly as it is, this is something that could substantiate the visibility of it and just kind of just show you how evil this world could be. You know, like from an advocacy perspective. I don't know. Hey, Shibby, what would you like me to? I do have some of them on my screen. Let me see if I can share my screen. All right, let me zoom in. So this is the formal complaint guide, or one of them, from the Office of the Indiana Public Access Counselor. So right here, improperly denied records. If an agency denies the record request submitted in writing, it must provide the statutory authority allowing it to deny the record. If the agency fails to provide this, or you believe an incorrect statute was used to deny your request, you may file a formal complaint. And then they have here inappropriate redactions. So another common complaint entails information incorrectly redacted from the records produced by an agency. Similar to denials, the agency must also provide the applicable state or federal law allowing it to redact certain information. So if I go here back to this email, sorry, I don't want to sound like a broken record. Jody did not do that. And then if I pull up, what is it? Is it this one? Sorry, it's loading. This. Okay. And we go here. right? Excluded from public access per rules on access to court records. That is not providing the applicable statute, in my opinion. I mean, to me, it would be like excluded by, you know, Rule 5, like Rule 5B12. I don't know if they have to go in that, like, in that type of micro level. Sorry, it kicked me off of that. So we have, so if we look at this, okay, February 13th, 12:44 and 28 seconds, right? So we got one redacted, and then it goes to 12:54. I mean, excuse me, 58. So let's just say this is excluded because it was a witness. That would, I would think that could mean this is when Bree Wilbur's some type of message from a witness came through. And then we go and all right, so it goes from February 13th at 1:25. We got a plugged in and charging, right? And then 13:38. But you know what? I mean, Becky Patty's information is on here, and Derek German's information is on here. And they were witnesses. Okay, so then we go from 1340. So to 1344. So right before she views these two Instagram files. Okay, so that kind of makes, like, I'm not saying it's right, but if she's viewing the Instagram file, that means there could have been an Instagram message sent to her, right? And that information is not here, or could have been a text message, or it could be, maybe it's excluded because they're still looking into Kagan Klein. Is this Kagan Klein's kick? And they can say, okay, it's still under an investigation, so we're going to exclude it because that is something that is allowed to be excluded. But which I'm just assuming. I was just trying to narrow it down. Like, what could be the reason we have actually 3 missing pages here? Or they may not even be full pages. I don't know. It could be like 3 rows. It's the pics that are marked confidential, and McLeland said all the pics came from the fake memo exhibit. Are you saying, like, you think these are copies? Because I read that if it's excluded by one, let's say, agency, it carries over. You know what I'm saying? Good night, Michael. Thanks for joining. Ignore Shibby. He's a nuisance. Anyway, okay, so going back to this, let me go back to the guidance document. Oh, you hear my dog now? All right. Can you see it, or should I make it bigger? Oops, let me take Michael's message off. Oh, no, that's worse. Okay. The formal complaint process first begins with an alleged violation of access laws concerning public records and meetings of governing bodies. A review of the handbook on Indiana's public access laws is recommended prior to filing. Common types of complaints include, but are not limited to, and I already went improperly denied records, inappropriate redactions. Yeah, so like that. Okay, so what we just looked at, where it said excluded based on the Public Records Act, right? How are you to counter that if you don't know which which like statute, like or provision of Rule 5 has been enacted, like what or what rule within the public access laws have been applied if they don't tell you what it is? Okay, second, actually the third thing on here, unresponsive agencies. An agency has 7 days to acknowledge a remote request submitted by fax, email, or U.S. Post. A delayed production of records. So they're defining this like on reasonable amount of time. And there was an opinion by the public access counselor relating to, what's his name, Ron Wilkins, when he filed a complaint saying, hey, I asked for, the log of the arrest and location of Richard Allen. And I don't even know if he knew the name at the time, but somehow he got word that they had arrested a suspect on October 28th, right? And the arrest occurred the 26th. And then that press conference, wasn't it like on the 30th or 31st? But anyway, he made a complaint, and in that complaint, the state responded saying that, like, hey, we're only required to release this information within a certain time period. And the public access counselor came back and said, no, if you are creating a log of all your, arrests and information, which you're required to do under the public access law, it wouldn't take you long to then provide that information to whoever's requesting it. Do you understand what I'm saying? So even though within a reasonable amount of time is not defined here, it's my perception that because of the importance of public access, like that trumps. Like it should be like as soon as possible, if that makes sense. Okay, next thing, excessive copy fees. Statutory fee schedules for public agencies are found throughout Indiana code. Depending on the type of record, agencies may have some discretion in types of costs. And then here's public meetings. which was like half of that manual. So this, now I hope you could see this better. This is what I was showing. That is this handbook that's really helpful. So I'll just go through this real quick because it wasn't able to be seen. Sorry about that. So this could be found on the Public Access Counselor's website. So it goes into like the open door laws. And then, okay, so what is the role of the public access counselor? To train public officials and educate the public in the rights of the public and the responsibilities of public agencies under public access laws, to conduct research, to prepare and distribute, that's like educational material, to respond to informal inquiries, and then to interpret the public access laws and to issue advisory opinions. Make recommendations to the General Assembly. Okay, who may utilize the services of the office? So members of the public, including the media, as well as representatives. Okay, what is the process of a formal complaint? So here's where it says a formal complaint must be filed within 30 days after the denial. This is for like records. The meeting is not applicable here, but like let's say your city or your town had a public meeting, and it was not in proper notice, wasn't posted. So anytime there's a government, like a public agency meeting, they're required to provide advance notice, with few exceptions to that rule. But generally speaking, they're supposed to have a notice. A complaint is considered filed on the date it is received by the public access counselor. Okay, and then once the complaint is submitted, a copy of the complaint is forwarded to the public agency which is the subject of the complaint. And the counselor requests a response from the agency. And I have a couple examples here that I want to pull up just to kind of give you an idea of what the public access counselor considers. Okay. Okay, so right here, must I file a formal complaint to obtain assistance? Members of the public and representatives of public agencies need not to file a formal complaint against a public agency to seek assistance from the office. So you can call the public access counselor and make an informal inquiry or ask a question. So here it says that, if they can't answer your question, basically, or complaint, they may reach out to the public agency to, seek more insight or resolve the matter. So is the public access counselor a finder of fact? The public access counselor is not a finder of fact. Advisory or informal opinions are issued based on the facts presented. If the facts are in dispute, the public access counselor, opines based on both potential outcomes. A judge would have the authority to make factual determinations regarding complaints filed before the court. All right, so right here it says, what is the significance of filing a formal complaint or seeking an informal opinion from the counselor? A person or a public agency seeking access to a public meeting or a public record may contact the counselor, but since the counselor's opinions are not binding on public agencies, the person may wish to file a civil action under IC, and then it says 5-14-1-5-7. Okay, so this one would be the one right here, this 5-14-39, or I'm sorry, 5-14-3-9, which would be, I guess that outlines the civil process for the Access to Public Records Act. Okay, if the person seeking access prevails in the court action, the judge must award reasonable attorney fees, court costs, and costs of litigation. If the person has not contacted the counselor prior to filing a civil action, these fees and costs will not be awarded unless the person can show that the filing of an action was necessary. Okay, so that is the benefit of going through the public access counselor's office. Because if you do file a civil action, you will not be awarded fees and costs unless you can show that the filing of an action was necessary. And that's what to prevent a violation of the open door law, or two, because the denial of access to a public record would prevent the person from presenting that record to another public agency preparing to act on a related matter. So if you can show that the filing was necessary, so say you don't go through the public access counselor, but you want to get attorney fees awarded to you, right? You would have to prove that the denial of access to a public record would prevent the person from presenting that record to another public agency. Okay. Now you can get law enforcement recordings. In cases concerning denial of access to public records, the public agency is required to notify any person who has supplied any part of the public record at issue and inform that person whether the denial was in compliance with an informal or formal response from the counselor. Are we ready? Went over that. Okay, so this is the 5-14-3-2 that is outlining also the public records. Okay, so remember how I said like so I think I already went through this, but like really like when they say inspect or copy, records, you can go and ask them to inspect a record. I don't know how that process would work because like I also read in here that they don't have to, like from a judicial perspective, they don't have to give you the right to like listen to audio recordings. Does that make sense? Like, so, but like inspect and copy are usually used interchangeably in this. All right, so let me go and show you. Here's one. This is an opinion of the public access counselor. So I just happened to find one that was Delphi, but there's tons of them. You can access former opinions of, like, if it's a public agency, it's all there's a bunch of them. It's just not police departments and court. But anyway, so this is a formal complaint alleging the City of Delphi violated the Access to Public Records Act. Delphi Clerk Treasurer Leanne Aldrich filed an answer on behalf of the city in accordance with Indiana Code 5-14-5-10. I issued the following opinion to the formal complaint received by the Office of the Public Access Counselor on May 17th, 2021. And the complainant is Gull A. Connor. And then, like I said, this Luke H. Britt is no longer the public access counselor. There's I forgot the lady's name, but anyway. All right. This case involves a dispute between a Delphi City counselor and the clerk. This is interesting. Sorry. Okay, so this case involves a dispute between the Delphi City Councilor and the clerk treasurer over access to copies of the city's bank statements. On March 25th, 2021, Delphi City Council member Gull Connor filed a public records request with Delphi clerk treasurer Leanne Aldridge seeking the following. So she needed January 2021 bank statements for each of the checking accounts held by the City of Delphi and their specific balances and the beginning of the year, or at the beginning of the year, excuse me. Aldrich acknowledged receipt of Connor's email request the next day. So that's good. She was within that window, that 7-day window to acknowledge, right? Clerk Aldridge informed Connor that she hoped to have the requested materials available within 1 or 2 weeks. In the meantime, Connor attempted to follow up with the request on a handful of occasions and never received any of the requested material. Connor filed her complaint on May 17, 2021. Notably, she received the documents on July 2nd, 2021. So was that just 2 months, less than 2 months, right? Clerk Treasurer Eldridge filed a response to Connor's complaint on June 10th, 2021. Aldrich asserts that unforeseen health circumstances and staffing issues led to a delay in the production of the documents. However, she did acknowledge that the material had been available since April, but no one followed up with Connor to let her know. So then there's an analysis. 1, the Access to Public Records Act. The Access to Public Records Act, APRA, states that providing persons with information is an essential function of a representative government and an integral part of the routine duties of public officials and employees, whose duty is to provide the information. Indiana Code 514.3.1, City of Delphi, is a public agency for purposes of APRA and therefore subject to its requirements. And then there's a note, see Indiana Code 5-14-3-2Q. As a result, unless an exemption or exception, applies, any person has the right to inspect and copy the city public records during regular business hours. Indiana Code 5-14-3-3A. Indeed, APRA contains exceptions, both mandatory and discretionary, to the general rule of disclosure. In particular, APRA prohibits a public agency from disclosing certain records unless access unless access is specifically required by state or federal statute or is ordered by a court under the rules of discovery. And then here's 5-14-3-4A. In addition, APRA lists other types of public records that may be accepted from disclosure at the discretion of the public agency. Here's another code. I'm not going to read all these codes. Connor's request. What is it? The crux or crux? Crux. I don't know. You know me. I have like a really bad accent. Hey, 1 second. Okay. The crux of the initial dispute is the timeliness of responding to a public record request with the responsive document. Under APRA, a public agency may not deny or interfere with the exercise of the right for any person to inspect and copy a public agency's disclosable public records. And then there's another Indiana code. Toward that end, the law requires an agency within a reasonable time after the request is received to either 1, provide the requested copies to the person making the request, or 2, allow the person to make copies, A, on the agency's equipment, or B, on the person's own equipment. Well, that's interesting. Okay, sorry, I had to vape real quick. All right, so the Indiana Code 5-14-3-3B1 through 2, the term reasonable time is not defined by APRA. And thus it falls to this office to make a determination on a case-by-case basis when a complaint is filed challenging timeliness. In doing so, this office considers the following factors: the size of the public agency, so Delphi is pretty small, right? 2, the size of the request, not very big, if you ask me. 3, the number of pending requests for the complexity of the request. And 5, any other operational considerations or factor that may reasonably affect the public records process. 1 second. Okay. Where was I? At the same time, because Connor's request was reasonably specific as a predicate, reasonable timeliness is simply defined by this office as a practical efficiency. Okay, so that's kind of like just like what I told you about the public access opinion about, ISP not giving the arrest information in time because they did, they should have kept the log. Okay. So here it does not appear that Connor's request was overly broad or complex. This office is certainly empathetic to difficult circumstances that give rise to unintentional delays in access. Still, a municipality, oh my God, should have the infrastructure in place to provide records even when personnel are out on health leave. Backup plans are always encouraged. As mentioned before, councilpersons of a municipal, I can't say that word for some reason. Municipal, it's like one of those words you have to say really fast. Municipality, I don't know. I can't say municipal. Oh my God. This is totally going to be a blooper. Anyway, I want to just skip that. You know what I mean. Should have ready access to documentation needed to, what is this? Effectuate their public business as officials. Record keepers are the integral part of information transmission process. From the clerk treasurer's response, it appears, what is it? Oh my God. Squish. I can't breathe today. Oh my God. Subsequent, records request was successful. It is my expectation that the trend continues, and I genuinely hope not to feel complaints between these parties again, lest a more heavy-handed approach is utilized. It is my expectation that the trend continues, and I genuinely hope not to feel complaints between these parties again. That's hilarious. So, like, that's an example of one. Let's see. Do I have? I think I might. Okay, this is the next filing. I already covered it, but I'm just going to skim through it if anyone wants to, like, on the rewind, view it. So I think I covered this, you know. Oh wait, here's one more. Here it is. So this is Allen County Public Defender's Office. So it's Brent Taylor v. Allen County Public Defender's Office. So this is an advisory opinion. This advisory opinion is in response to a formal complaint alleging that Allen County, let me make this bigger. Okay, alleging the Allen County Public Defender's Office violated the Access to Public Records Act. What is this? Okay, so this is the code right here. The agency did not fully respond despite several invitations to do so. In accordance with Indiana Code 5-14-5-10, I issue the following opinion to the formal complaint received by the Office of the Public Access Counselor on September 27th, 2023. Okay, let me check in with chat. I don't want to feel like, I hope I'm not ignoring everyone. Sorry. Oh, hi, Daisy. I don't know if I said hi to you yet. Oh, Heather, I hope you didn't have that too bad of a bad day. Sorry to hear that. Whatever you're going through, I hope it will be resolved and a happy ending. Let's see. Yes, you can absolutely trigger Shibby. Sorry, I'm still reading. All right, I think I can go on. All right. On September 13, 2020, did I read that part? I don't know. I'll read it again. 2023, Brent A. Taylor, the complainant, submitted a public records request to the Allen County Public Defender's Office seeking the following documents. So they wanted all agreements between the Allen County Public Defender's Office and the Allen County Prosecutor's Office regarding discovery practices pertaining to individuals represented by the Allen County Public Defender's Office. This includes, but is not limited to, the following. A, agreements regarding the distribution of discovery materials provided to attorneys contracted with your office by agents of the Allen County Prosecutor's Office during the course of representation of individuals represented by attorneys contracted with your office. Just one second. I'm going to take a drink of my Diet Coke. Okay. B, all policies regarding the distribution of attorney-client files to individuals represented by attorneys contracted with your office. So they're looking for like their best practices, right? That's the way I interpret this. Okay. C, all policies concerning the obtainment, preservation, and destruction of the foregoing requested documents. Taylor did not receive a response and filed his complaint on September 27, 2023. So wait, I want to go back and see. Okay, so it exceeded the 7 days, right? Because he filed, so he requested this to, on September 13, 2023, and no one acknowledged. So he did not receive a response as of September 27, 2023. This office solicited, a response from the director of the Allen County Public Defender's Office on October 2nd, 2023. So it looks like, hey, the counselor's trying to, escalate this to try to, get a response on their behalf of Taylor's behalf. On October 4th, the office was responsive and submitted several court documents regarding discovery in Taylor's criminal proceedings. Not seeing anything by way of agreements or policies, so that's what he or she was asking for. Excuse me. This office sought clarification the same day. After not receiving any response, we once again asked for clarification on November 8th whether any policies existed. This time, on November 9th, the Allen County Public Defender simply stated, the discovery practices of Allen County are governed by the local trial rules, but did not address the question whether there was any agreements or policies responsive to Taylor's request. Therefore, we once again ask the yes or no question, whether there was any documented agreements or policies. This query was met with silence. Analysis. 1, the Public Access to Public Records Act. Okay. Says the Access to Public Records Act, APRA, states that providing persons with information is an essential function of a representative government and an integral part of the routine duties of public officials and employees whose duty it is to provide the information. Indiana Code 5-14-3-1. The Allen County Public Defender's Office is a public agency for purposes of APRA and therefore subject to its requirements. See IND Code 5-14-3-2Q. As a result, unless an exception applies, any person has the right to inspect and copy the office's public records during regular business hours. 2, cooperation from public agencies. Indiana Code Section 5-14-5-5 expressly states that a public agency shall cooperate with the public access, looks like emphasis added, counselor in any investigation or proceeding under this chapter. I got like take 1 second. Another sip of this Diet Coke. Thank God I brought 2 cans. Okay. Indeed, the chapter reference in that statute is the one that governs the formal complaint procedure administered by this office. In other words, public agencies must work with this office in any formal complaint investigation or proceeding. Here, this office sought a simple yes or no confirmation on 3 separate occasions, but only received an unhelpful and dismissive answer. The answer was likely that the public defender's office does not have any documents because those procedures are indeed governed by the Indiana trial rules and the county local retention schedules set by the Oversight Committee on Public Records at the state level. We will not, however, make the presumption on an agency's behalf or give it the benefit of the doubt without express confirmation. Nevertheless, the public defender would not grant the professional courtesy of a definitive response despite being asked 3 distinct times to provide one. This office is aware that the Allen County Public Defender has a high workload and that Taylor's request is quasi nonsensical in context. Looks like a Latin. Okay. The public access counselor also has direct experience with Taylor demonstrating difficulty or unwillingness to appropriately navigating both the trial rules and the public access process. Wow. Even so, when this office calls for a response from a public agency, it has a statutory duty to cooperate. We typically do not ask more from agencies than a good faith effort to state a position. Here we ask for the minimum, but we're unsuccessful in obtaining even that. Conclusion. Based on the foregoing, it is the opinion of the public access counselor that the Allen County Public Defender's Office violated the Access to Public Records Act. Signed by Luke H. Britt, Public Access Counselor, issued December 6, 2023. So that's that. Those are 2 examples of kind of like what an opinion looks like. I don't know what happened after this. I think like if they don't have a like written procedure, like they could have just said, we don't have that. Because like he was only asking, does this exist? Yes or no? Because I think if the answer is no, right, then how do you give somebody access to a record that does not exist? You know what I'm saying? But it seemed like they had to be, extra about it. I did not say that, Shibby. Why you always lying? I'm just catching up with chat. Yeah, JP, I'm having a really difficult time with my iPhone right now. I don't know what they did, if it was like the last update, but it keeps on like booting me out of apps. And it's not just like one app, it's like several of them. Let's see. Did I miss anything else? Okay, I think this is like I don't think this is applicable. I don't know why I downloaded this. Oh, this is the rules of professional conduct. I don't know why I downloaded that. Okay, so this is the list of the exhibits. I don't know if I blew this up last time. And this is what I was referring to when I was like, okay, does it go in and out of the system the same way, right? So if you mark something confidential, is it up to Jody to say like, no, this doesn't qualify, it's not, exempt? And then, like who changes that, right? I don't know. But this is what I was talking about, like how some of these were marked confidential. Like the autopsy photo is definitely not allowed. So yeah, that's confidential. Look there's a DNA documentation. I don't know what that is. I'd have to look at the Frank's motion. But I could think that that might be under the medical area. I'm not sure. Definitely not an expert. I'm just trying to give everyone the information about this topic. I think autopsy notes might be allowed. I'm not sure. Actually. Okay, and this is rule 5. It's still not big enough, is it? Mm-hmm. So this is where no notice of exclusion is required. Okay. Yeah, I don't see anything about that. This is some commentary. Rule 5A begins by recognizing that in some instances, an entire case shall be excluded from public access because all court records have been declared confidential. But rules 5B, C, D, and E make clear that in most instances, it is only individual case or administrative records that have been declared confidential. A court may take judicial notice of records that are excluded from public access, including records in cases where all court records have been declared confidential, such as juvenile cases. Yeah. This is what I was saying right here. The reference to court rules in Rule 5B2 does not refer to local court rules. Counties cannot impose local rules that conflict with the Indiana rules on access to court records. Okay, here's something I forgot to point out. So within one, I forgot which one it was, but there was, I think it was an exhibit to the contempt hearing that Hennessy filed, if I'm not mistaken, or maybe it was Nick McClelland's exhibit. But anyway, subparts 11 and 12 do not include a painting, drawing, or other similar representation. So there was like there was a drawing that Rob Fortson made, and that was excluded. I believe so. I'm pretty confident. And it's saying here, if it says painting, drawing, or other similar representation, that is not part of the Rule 5B11. So that's that. Just something I forgot to mention. I think this is pretty much. Yeah, this is redundant. I think I've covered all this. Yeah, but there's a lot of information out there. Again, if anyone has filed a records request and was denied and it's not proper based on like everything we covered today, I think, you know, a complaint would be warranted, in my opinion. I mean, people obviously can do whatever they want to do. It's just I don't know, I'm just like one of those people that just like really like transparency, and this thing, like this topic just drives me nuts because it's just like it seems to be, you know, consistent throughout this entire case, you know, from when it started, you know, at the hey, let's seal these records and let's, you know, send Richard Allen to, you know, White County and then Westville, right? And then, you know, recuse ourselves from the case. And then, you know, like all these people are like, what's going, because like this is the highest profile case in Indiana's history. If not the most, one, like top 3, I would think. And, it took just a very long time. And it just seems like that it's still an issue here. So it's like something that just continues through all the way through the, we're now at the appellate level, and, still can't get documents, and no one's providing the reason for. So I have an issue with that. Like, we try people in the light, not in the dark. And it just like, I think it's really something that, continues to have, when people, well, let me rephrase this. When people don't trust the government, they're going to ask more and more questions. But if you are transparent as possible and you give the public access to, what is required by law, I think there would be, less questions being asked, or at least some answers that people are, seeking. And that's the mere reason why this law exists. Public, the public access records. Yeah. So that's all I have. I'm just looking at chat. My voice is like going. Does anyone want to join me? If not, I'm going to call it a night. Or if you have any feedback or comments in here, please provide your thoughts as to how you feel or what you think about what I've covered today. I know, like, crime scene photos are a sensitive topic, and I see either position, to tell you the truth, as far as like why they should not be out in the public, right? But then I also see an opposing view to it as to, it is required. You know what I mean? So I think everyone's entitled to their opinion on this topic. And I don't think there's a right or wrong viewpoint on this. Sorry if I'm not taking a position, really. Because like I said, I don't know how I would view this if this was my child. It's like one of those things where you could say you're going to do, act a certain way or think a certain way until it happens to you. All right, so I'm going to put a link. Let me stop sharing my screen. Let me know if you got the link, Shivers. And I just have like one rule, just like anyone that comes up here, I try not to talk about other creators and what other creators are doing. It's just, hey, what's going on? See how I invited you back?
Well, of course you would. Look at your views going way up.
Yeah.
You got someone interesting now.
Oh, well, thanks. Like, what the hell were you trying to say there, Shibby? I don't appreciate
that. Well, you got beat badly in that competition we had. So, Team Shibby.
Oh, yeah.
Put a 0 if you want me. How's it sound? Okay.
Yeah.
Too loud? Am I too loud? Or?
No. I mean, I think it's a little bit different on the YouTube end of things. I think the sound is different. So I mean, I think you sound fine, but I thought you sound fine the other night too. So I think let's poll the audience. Does everyone think Shibby. I almost called you Sibby.
Mhm.
Does everyone think Shibby sounds okay?
I think if anything, it's my volume input, like my mic level,
Uh-huh.
because I set it to automatic, and it just kind of, it's resting close. My headphones are like really close to my neck.
Yeah.
But anyways, I think if I just try to talk not loudly, it sounds better, I think. Anyways, so what do you want to do? Want to read more, or are we doing other stuff?
No, I think I'm done reading.
Oh, okay.
But I think of like a conversation, as far as like the records, access to court records and the content I covered. Like, what's your view on that?
On that specifically, or just in general, like the FOIA stuff?
That specifically. I mean, I think like if they're one and the same, kind of like the public access to records is pretty much FOIA, but just on a local, because FOIA is the federal.
Right, or
Um,
whatever. Yeah.
yeah,
Well, I think that they're probably overloaded too with people. How many people? Is it just one woman doing it? That one lady?
yeah, I
So
think
they
so.
probably
That
get
is a good point.
bombarded. But then on the other hand, they get a little they forget who their boss is in a way too.
Yeah, I think I've
That,
seen something where there was like feedback that Gull said no on some of the requests. You know what I mean? It's like,
right. Well, you know what it was? Oh, I remember the credentialed media distinction with like all the real media versus the people, which there is no distinction. Yet she made one.
exactly.
So yeah, like, I mean, I'm surprised somebody didn't give her a civil rights uh, lawsuit because she can't do that.
No, and even with the whole access to the court,
Right,
during trial, the
yeah,
way, and that's a whole nother topic, but like the way I read it, like the media is like, it's like the public. You know what I mean? Like they're one and the same.
right.
Unless I missed something, but when I went through it, like as far as access to court, it's the same. So
There's the way she did the whole lineup stuff and all that control. She had way too much control and saying no to the cameras. There's no distinction. In the USA, you guys have your First Amendment is free press. Any single person who wants to disseminate information to another person is media. It's in your first, uh, it's your first one. It's your first, what do they call it?
amendment.
Amendment.
Hmm.
Yeah, it's free press. If you want to learn something, go to any public court and then go and tell people your press. And she allowing others to come and look at certain things and telling
Right.
others, that's not right. It's totally illegal. And I'm surprised nobody's filing a lawsuit against her.
Yeah. I mean, good point. I think you had like 30 days to do that. At least like from like if you wanted to go the route of filing public access. Um,
Right.
you
You know
know.
what? Also, it felt like if you didn't toe their line, you didn't get access.
Hmm.
If you didn't follow their narrative and accept their views and stories, you didn't get access, and it shouldn't have been like that. Remember, Andrea Burkhart was going on, no cameras, no wonder. Like she was totally out of control. And these people that accept that, when it's going to be working against them, they're going to wish they hadn't. It's going to be them next.
Yeah, I mean, I totally can understand why you would want to have some control over the courtroom. Like, I do understand that, but at the same time, I think a lot of it was like self-created. Like
Right.
if you would have
Right.
just given people access, like I don't think, from a streaming perspective, that a lot of those issues would have not been applicable. You know what I mean? So,
Right. Like
um,
control is one thing, but making distinctions in media and people and allowing certain people to do this when there really is no law for that. That's what she did wrong.
Mm-hmm.
Like she was saying, what's that one, the Comet, or any of those news stations would have got preferential treatment, and they sit there and say because they're real media, and it's just there's no it's not true.
Mm-hmm.
So
Yeah. She wanted credentials, right?
right, and your credentials, you could, like I said in that one show, you could draw up a thing saying Peggy Media Company in crayon with a couple letters backwards, like as a 3-year-old would write it, and your media. You want to get public information and disseminate it to your peers and other civilians in your community, your media, no matter how they want to look at it. They want to think that YouTubers and podcasters and want to lump them all together and say that the official news can say hear this and look at that. It's not right. There's no law for that. She's out of line.
So, learning what we just did as far as, public access laws, what do you think is the reason behind these exclusions?
I know. My opinion is they're stuck in the 50s, and that's how it would have been back then. You do as we're in control here.
Mm-hmm.
They want things to be like it was way back when, and they don't want to accept that people are learning their rights now and are pushing for information and all these new ways of getting the information, especially with social media and that. They were so used to getting home and looking at the 6 o'clock news, and that's the mainstream media. They're the real the media. Everyone else isn't. Well, they have to learn to accept that it's not that. It never was that way, but it's not accepted anymore for sure. Is that what you wanted to ask about?
Yeah, I'm just thinking here that, like, even though it's not a correct interpretation from what I reviewed, right? Like, this is just my opinion, but even though it's not a correct interpretation, I think the position was the exemption for juvenile witnesses.
Oh yeah,
You know what I mean? Like, and I think it's very probable that, around 140 is the time that Bree sends Libby these Instagram files. Because,
definitely. Yeah.
If she accessed those files, let's say, just going through Snap, like Instagram, like on a story, I don't think that would be necessarily excluded. So I think it kind of like, I'm just trying to figure out what this could be. And I know I'm just playing the guessing game at this point.
Well, I think
Mhm.
you're talking about how old were they when they did it?
But yeah, that's another good. I think I know where you're going
Like,
with that.
they're gonna.
I think Bree testified she was like 16, maybe during that time. Like she was a junior.
Well, I don't know the laws in every state is probably different, but here in Canada, it'd be like 14 years old. Then yes, you should redact their personal information. But the
Mm-hmm.
pictures she took, they probably tried to use that to withhold some stuff that they probably weren't allowed to, under the excuse of it was a minor who took it. Like they push boundaries like that, which it just really looks suspicious to people, I think.
Yeah, I think I see what you're saying here, but I think this is just like the pictures, I believe, are out there. And the description of the file, says like there's two of
Right.
them. One is a wooden bridge in a body of water. And then the second one is like the weird sticks.
I'll be
So
honest, I cannot see what you have written. It's way too small for me on both StreamYard and I have
really?
YouTube muted. Yeah, it's tiny. I have both of them on my 52-inch screens, but to see chat and all that at the same time. Well, I could probably open up a third window and make it full screen. It's okay. Don't worry about it. I'll open up a third. But for me to be able to read chat and do all that, it's kind of a bit small. One sec. Like I have it full screen, but I also have it so I can read the chat too. So I'll do
Hmm.
two of them, and I'll close the chat on one of them.
Oh, that's okay. That doesn't work.
Okay, I can see it much better now. What are you reading? Which
So
number?
see how there's 1, 2, 3 redactions, or not redactions, but exclusions. So we have at 140, almost 141. Snapchat app not in the foreground. And then
Oh, okay.
1, 2, 3. And then the next thing here is at 144, to Instagram files. So I was just trying to figure out what could be like what, I don't know, maybe I'm trying to interpret somebody that's not applying the law correctly, but
Okay,
whatever.
yeah.
Yeah.
I was looking at the number on the left, so yeah, the time.
Oh yeah, this is like UTC right here. So
No,
this is
no,
like,
no, it's okay. Yeah, okay, I see. And you got military time too. Or, you know,
so we have that 3. I think it's just 3. Wait, here we go. 297. I don't know why I didn't think of this.
why does it keep
Oh
disappearing?
my gosh, look at this. So it
What?
goes from 247, right? That's the last row on page 10. And it goes to 297. So it looks like they instead of like just let's just say hypothetically they're using the witness provision, right?
Mhm.
There should just redact that on this Excel file. It looks like an Excel file, right? They should just redact the line that is like excluded, whatever information that is. But they're redacting full pages.
Right, they're leaving it all out, whereas it
Mhm.
should be all just redacted. But they
Yeah.
should still be like a placeholder to let you know that there was something redacted.
Well, yeah, there is a placeholder, but they don't say why. It just says excluded from public access per rules on access to court records. Like it doesn't say which provision, within the act. So that's interesting. I didn't catch that before. I just thought like it only would be like 1 or 2 rows. You know what I mean? Or 3 rows,
Right.
but like they just
Right.
like totally redacted everything,
I mean,
which
that's why doing this is good, because I feel like every time we read something or do something, I learn something new and just in us talking, we bounce off each other and read the chat, and then boom, we brainstorm up and, it's called free balling. We come up with something that we didn't even think of, or we realized
mhm.
we were wrong, or we realized we were maybe missed something. Every time. I've seen all these things a million times, and I feel like I learn something new each time. So I'm pretty good with the numbers and noticing like when things are not, when there's an anomaly, when something's wrong, it kind of stands out to me. I've always been kind of like, my superpower would be like, I would be called Rain Man, like when he drops those toothpicks and sees, whether it's 73 toothpicks on the floor.
Yeah.
I see things in numbers like that. My whole life I've kind of, and everything peripheral. I've always been peripheral, like playing sports. I can see everything, but what I'm looking at, I kind of take for granted, and I see everything else. I'm thinking of everything else that I shouldn't be. And like when
Yeah.
I hear things with the microphone and the sounds, I hear everything. So I'm not like a savant or a whatever they call it, but They're probably on some kind of spectrum somewhere.
So yeah, 4 pages, 10, 11, 12, 13, actually 3 pages, right? No, yeah, 3 pages. And it's only 4 minutes. So within a 4-minute span, have like all this activity going on. And this would be right around the time they're pulling up to the trails. Like that is like that could give us more information. Like were they meeting somebody? You know what I mean?
Oh yeah. Plus, there's lots missing too, like all the McCain stuff. He's out there with a, really expensive DSLR camera around his neck. I mean, shouldn't there be millions of photos from him out there?
Can you repeat that? You kind of cut off. Sorry.
Oh, sorry, a McCain. How did I cut off? Was that too loud or too not speaking loud enough?
No, you're fine now. You're fine.
McCain, all of McCain's info. I'd like to see a breakdown of this on his camera,
Right.
all his photos. Because I mean, what if he's taking photos and we'd see a guy in a bike in the background or something? I don't know.
Yeah, I
As
don't
if he
know.
didn't take.
I don't think that was ever introduced as an exhibit or attached in a, pleading or motion or whatever you want to call it. You know what I mean? So I don't know if we can get that.
Like he had a memory card, right?
Yeah.
And wasn't. Where's that? And why is he getting off so scot-free? Like he was there. Why wasn't he up on the stand and pointing out things and making adding to just sketches? And I don't know, unless he did, and I don't know.
Well, I was watching some old videos. I think the creator name was Michael Catt. I don't know if you ever watched any of those, but I think he talked to David McCain, assuming he's flannel shirt guy. And David McCain, I guess this is all hearsay, right? This is like he said, she said type of scenario. But David McCain said that he ran into somebody who they thought was Bridge Guy. So I don't know if that's true or not.
Well, did you see that interview on True Crime Jesus years ago? Put out a video, and it was with him, somebody interviewing McCain. Probably what you're talking about. And that McCain is very very artsy fartsy kind of, um, you know. He looks like one of those guys who would be an artist, just very what's the word for it? There's a name for it. Not eclectic, not flamboyant. I don't want to say flamboyant. There's a good one. Eccentric. I was thinking eclectic, but I thought he was like a nice guy, but one of those odd guys. And he's out there with a camera. He's firing off photos, especially nowadays when you don't have to waste film. It's on a memory card. He'd be just clicking away, taking video and everything.
Right.
I changed my mic setting. Is that any better?
I mean, it wasn't bad to begin with. I think it was my internet kind of.
No. Whenever I set StreamYard to do it automatically, it turns it right down to like 8 out of 100, the input of my microphone. So I set it, but 100 is too high. Like it sounds overdriven, like UCC was saying the other night. So I set it right at 50%, which seems to be good. So, and I turn it off because for whatever reason it jumps up and down and goes way low when StreamYard controls it. So, anyways, ignore me. I won't. How about this? I won't say anything unless you tell me otherwise. Because I get stuck on these things, and obviously,
you
know
do.
it by now. Oh, I know. Hey, I know.
So do
I mean,
I. I get it. I get it. I'm just
okay,
giving you a hard time.
I,
It's
I
payback
could
for
loop,
your comment earlier.
and I deserve it. I'm sure because I could loop in an argument when we're both saying the exact same thing. It's like I get stuck in that loop, and I think we did it like 5 or 10 times on that live stream the other day. So we'll need a safe word where you can kind of get me out of this loop.
So I'm just looking back at what Micah was saying about the Excel, like this document we're looking here said that Excel thing is cherry picked lots more in the actual phone data. Okay, so I think what he's implying here is that there's things that did not make it into the spreadsheet. And I'm told, like, I hope I'm not putting wrong words in his mouth, but that's how I interpret what feedback he's providing here. So
No, it's like, I mean, listen, hey, don't ever think you're doing anything wrong because if your intentions are right, just like us the other day, remember I jumped in and said something about that timestamp and I thought it was something else. And by just jumping in, you said something and I said something and I realized I was wrong. So, I mean, as long as we're well intended here, it's okay to be wrong. Just that's how we come up with the right stuff. That's how I learn everything. Screw stuff up. So go on, sorry.
no, it's okay. I'm just trying
You
to
know what I'm
see
saying? Like, don't
who.
think you're doing anything wrong. If you get something wrong, hopefully we can say something wrong, and smart people like Dave and Heavy and Mustang will point it out, and we'll learn the right.
Yeah. Mm. Fruit Loop, he says.
Mhm. Oh, I definitely. Yeah, I get
Hey,
stuck in there.
do you mind keeping everyone like entertained for a second or
No problem.
engaged at
Uh-oh.
least? I'm gonna just
Yeah.
take a quick step away from my computer. I'll be right back.
Oh,
Probably like 2
okay.
minutes. Okay.
So
Thank you.
leave that up on the screen. Leave it up on screen, right?
Yeah. Sure.
And we'll
Okay.
look through this. Okay.
Where do you want me to leave it?
No,
Do you
that's
want
fine.
to?
Right? No,
We can
no,
go
that's
right
good.
here. Okay. Cool.
Perfect.
All right.
Fruit Loop, eh, Dave? So what do you guys want to read? Anything? Any suggestions? Any comments? Any compliments? Any constructive criticism? Any shit talk? I'm just kidding. Oh, Dave, my family in Jamaica, they got moved to a different hotel, but they're still stuck there, but they're fine. They're not, they're alive. They have Wi-Fi and electricity, so we're getting updates of the Hurricane Melissa. And they were stuck in Jamaica and in Montego Bay. So I had aunt and uncle, and my cousin and her husband were all stuck there. And then they had to leave their rooms and go to some like huge gymnasium where they were all hunkering down. But everything's fine now. Hi Gretchen, how's it going? So do you guys have anything you want to talk about? What Peggy was talking about, the FOIA stuff and all this information on the screen? The redactions. Oh, Dave, can you put that link in chat? I've never seen Dino's OnlyFans page. You know what the problem was? I thought Dino's page got shut down because um, he owed them so much money because he was making very little because it ended up turning out that people were not paying him enough, and then he owed OnlyFans money, so they shut him down, and that's why he ended up out on the street corner. I'm just kidding.
Thank you.
You're welcome.
Sorry. I
No,
had
I
to
only
like
choked.
get a snack because I'm like starving.
Cool. No,
Mm.
I think I only choked 2 or 3 times, so it's good. Mhm. It's kind of easier when we're reading something. Got something to do.
Yeah, I just like pulled it up. Like we don't have to look at this.
No,
I just thought it was interesting, like just like an example, you know?
no,
Like
it's good. I can't even because I can see it, but it is a lot of information to comprehend. That one looks good.
yeah, this is weird because like 205 wasn't that when the one of the photos was it the Libby photo? I mean Abby photo?
Right.
And
Snapchat one that nobody can find in real life.
look at it, this is excluded. So
So
358. So
okay.
from 350, like that's the row. So like the time 205 and 8 seconds. So we have a whole. Hold on.
So what is the
358.
color codes? What is the color coding? Where's the legend? Because black is redacted. Is there a legend to
I
tell us?
think so. I think so.
They'd have to
Let
at the
me
very
see
first
if I
page
can
would
find
say
it.
red means this, yellow means this, because black is obviously the redactions, right?
Mm-hmm.
Or does that mean screen off? I don't even know because it was so small before. It's kind of like the first time I'm seeing this.
It's the same image I was displaying the other day, or the same size.
What other day was I here?
When we were looking at the phone data. No,
Me?
no, no. It was just
Oh,
no, when I don't know. It's like maybe a week ago actually. When the last time I had this up. So I'm trying
so
to
what are the
check
colors?
here
Oh, okay.
for the
Yeah, we
trial
actually
exhibit.
have the legend, the colors, what they mean.
Yeah, I think there's a
But yeah,
report that does go into you know, provides a legend. Not positive, but I'm gonna check.
well, they would have to include it in this report. They're going to use color coding to signify certain things. They're going to have to put a legend in to say the red means this. Or did you add this color?
No, I did not add the colors. Mm-mm.
Okay, so they would definitely add it, or maybe look at the end or the beginning or wherever. They definitely would put a legend saying what it means
Or it could be in the transcripts where it's just being talked through, you know.
somewhere, unless
Mm-hmm.
ah, I mean, so do you know what the colors mean besides black, which is
No,
redaction?
that's what I'm looking for right now. I don't know if you
Right,
heard
right,
me,
right.
but I'm trying to pull
No,
up.
well, I heard you.
I have no idea what the colors mean. I mean, I could see some
Right,
consistency and, you know, certain things being color code the same color each time, but I don't know if there's any other
right.
meaning behind some of these. You know what I mean?
So this is going to be a loop for us because I'm going to get stuck in a loop because I can't sit here and talk about this stuff not knowing what the colors are. It'll drive me bonkers. And it probably might be just me, but I'm very overly specific, probably. Hey, can you drop this file in our Discord and I'll help you look through it?
Well, no, it's not. So it's not affixed to the. There, like the first page starts off here. You see?
Mhm.
So there's another document that I have to find that would explain the colors. Does that make sense? Like it's not in here?
Right, right. Yeah, it does make sense to me.
But I'm sorry, what are you asking for? Like this
For
document
that
itself or?
I don't know, wherever we can look for to understand this, because it's gonna, I would love to know there's orange, there's yellow, there's blue. They must mean things.
Yeah, I don't have that like saved,
Oh,
so I'm trying to
okay.
find it like in
It's okay.
in the CCF here. I wish there was something I could send you to help.
How about this? I'll entertain chat. So
Okay.
Gretchen's here. Hi, Gretchen. Hmm. Dave, my 50% Canadian friend, is here. Good thing. Where are you looking at this document? Is it from All Eyes site?
Yeah. But see, like this is an exhibit P, a defendant exhibit P. And I don't think this, I could be wrong, but I don't think this is like an exhibit in trial. So it's like an exhibit to another pleading. Does that make sense? I have to find that. I could be
Right.
wrong.
Don't let me distract your whole thing here. If it's not what you want to be doing. But I mean, if those colors mean stuff, I think it's silly to talk about it when we don't understand what we're talking about, in my opinion. And this is that part where Heavy's going to say, I'm thinking about it too much. But I mean, specifics, they really mean things to me. And if there's a legend saying that the blue means this, the gray means this, I'd like to know.
I think it's an exhibit in a um I think it's an exhibit in a deposition actually. Mm.
Unless you want to just switch to something else and we can come back to this another day when we find it.
Yeah, we could ditch this. I don't
I mean, uh,
it's
whatever you
fine.
want.
No, let's ditch it.
Yeah, probably. 'Cause
I think really the purpose was just to kind of like give it an overview or like try to put together pieces to this because we're not
well, it's
given,
interesting.
I guess
Yeah.
does go with the topic, the theme of this live stream as
But
to,
you know
Hmm?
the Snapchat photo that nobody can find that they used that we all have watched looked at for years. Isn't
Yeah.
that wild? Well, it's not in trial.
Yeah. And it's wild because also it's like in the timeline where there's an excluded, you know what I'm saying? Like
Oh yeah.
1205, right? And now we got
Mhm.
a page that's blank. Like, what the hell? That's so weird.
I mean, in the beginning, it was called the Snapchat photo murders, right?
Mm-hmm.
Now there's no Snapchat photo.
Oh, here
And
we go.
do you remember why they said that? I think I remember what I heard. I'm not even sure if it's true, but that one of their friends saw the photo and screenshot it, and that's how they got that image. Because doesn't
Yes, I
Snapchat
heard that.
disappears,
I
right?
heard that. Mm-hmm.
Like one of their female friends or a cousin of Libby's or something. Hey, you know what we could do?
Hmm.
Like, this is very interesting to me. So did you have plans or something? Like, if we just literally read each line and think about it, we're gonna, I feel like I'm just kind of looking at it all as one, and I'm not focusing on each one. Or did you have something you wanted to do, or did you plan on finishing? I have no idea.
You're overthinking
Yep.
things.
Right. I do that. Yes.
I found it in the transcript.
Ooh, then share it.
I'm seeing if there's a color. Okay, so
So what?
we could read this together, actually.
Ooh. Is this
Okay.
what you want to do? Because I
Mm-hmm.
find it very interesting. But I'm weird like that. Like I see everything all at once, and I don't focus on the one thing I should be. So if you wanted to pick out important things, like just
Can you see it okay?
not now, small, and I'm zoomed. See, is that your browser? You need your browser settings. There you go. There. Oh, boom. There you go. Perfect. Because I have my YouTube open, which is muted, but also I have it on a separate monitor, zoomed in without the chat. So that's perfect. Yeah, I can read it very easily. Ooh, like we're gonna read? Okay. I definitely like that more because it's like we stumble on stuff and then talk about it. I find that interesting. But
All right, we can start with the sidebar.
yeah, anything.
I'll be Gull. Okay. How did you determine Mr. Allen had no connection with AW and LG and unaliving from the phone data?
I'm okay with that. I was gonna recall him because of what we talked about. Blah blah blah.
So you'll be recalling him back up?
Well, we may not have to now. I'm okay with it.
Any objection? Or will be LG or no? Nope.
I don't know because I can't read. Uh, did you go past it? What are you doing?
I'm
I'm
at the
reading
same
your sheet.
spot.
I usually don't have a problem because I'm usually controlling it. But now that you're flicking it all around, I don't know where I am. Did you
I'm
you
I'm still
skipped
sharing
something?
the same window. I'm
Not,
looking at it on the
no.
screen as it's being
Okay.
displayed in
Well,
StreamYard.
okay, so it's
And
my fault. Well, we may not have to now. I'm okay with it.
I think we did this already. Any objection? Ajir, nope. Okay, McClellan.
Well, we've got to talk about something. If we're going to go down this road and the defense is going to open the door to this, there is information on one of the devices, like he searched, there was a Google search.
You're still you on one.
Well, yeah, I see it. Maybe there's a lag. It might be, but do you have this document? You want to send this to me and
It's okay. I'm going
just
to ditch this. It's okay. This is going to be, I think there's just like a technology issue right now. And this is just like ad hoc, not prepared.
well,
So I'm going to just
I'm
ditch this
reading it on
idea.
YouTube. I'm reading it on YouTube. I could read on
Oh,
stream.
you gotta go in StreamYard to see this.
Okay.
There's
Okay.
definitely a
Okay.
delay in YouTube. Yeah, yeah.
Okay. So I'm on StreamYard now, full zoom on my computer.
Okay.
About Abby and Livy and how to best kidnap someone. All these different things.
Oh,
And so if we're gonna open this door about there's no connection, I just want to make you aware of it.
well, and that's way after.
I'm just
Okay.
I just have concerns. That's not. We can talk about the sketches and opening the door. I'm going to ask to bring it up. I guess is my opinion. So, anyways,
Okay, and then this is Gull. On the first report on 2/13/2017 at 2:05 p.m., the photo depicting Monon High Bridge with no one depicted in the still image. Did you ever locate or print this photo? So these are okay. Just give everyone these are juror questions. So they're going
yes.
through. Okay. Ajir, I'm fine with that.
I thought that was a photo of the bridge, no one on it.
Miss Ajir, you have it inaudible.
I thought we did it in one.
Was one that one of the girls took?
That's what I thought.
Was what? And then Gull. Weird. It's a weird.
What's it
Then
look like? Oh, sorry, my bad.
Ajir, what does it look like?
Yeah.
The court says it looked like it was like filtered. Miss Ajir, kind of black and white. The court, yeah, black and white, that one. What is this? Or sepia? Sepia? Or, yeah.
Is that the photo that?
I don't know.
Can you read that again?
And that's the inaudible photo. The court, 12/14/17, 2:05. The photo depicting the Monon High Bridge with no one depicted in the image. Did you ever locate or print this photo?
On her cell phone? I'm okay with it. I'm okay with the question.
The court, okay. What are all the blank spaces under the events section on the timeline in your first report?
That's a good one. I'm okay with it.
The court, how does the phone receive iMessages, FaceTime calls, telephone calls, but no SMS messages after 2/13/17 at 4:06 and before 4:33 a.m. on 2/14 without a signal via cell tower or Wi-Fi connection?
I'm good with that.
The court, have you ever checked to see if AT&T had any tower issues between 4:06 p.m. February 13 and 4:33 a.m. February 14?
I'm okay with that question.
The court, are you aware if Snapchat saves photos not uploaded to the story?
I'm okay with the question.
The court, do the pictures that get sent via Snapchat get saved anywhere?
I'm okay with that.
The court, are you having any objection to this? Miss Ajir, no. The court, okay. Miss Ajir, you know me, that's the court. No, I don't. That's why I'm asking. Miss Ajir, okay, sorry. The court, can iMessages be sent via cellular service?
I'm fine with that question. Now that I understand what's actually happening, it definitely is much easier. And I'm not lagging. So go on, sorry.
The court, how much data would be lost if the phone has been off and it stores a month of records? For example, if the phone is shut off 2:15 after method 1, then on off February 21st, then in 2019. That doesn't make sense. I don't even know what I'm saying. That's a question.
I don't even know. So wait, the question ended with the brackets, and then Gull added, "That doesn't make sense. I don't even know what I'm saying." Because you see how the quotes. The quotes
Oh, okay,
started
okay.
with the
Gull
question.
said that doesn't make sense. I
So
don't even know what I'm saying.
yeah,
Okay.
so she's reading the question, and then at the end she throws in, "That doesn't make sense. I don't even know what I'm saying." And now McClellan, I'm okay with the question, but I don't think I even understood it. See, this is why it's good, because it's funny.
Messager, yeah.
But I'm okay if you ask it that way and see what he says.
The court. Well, I'm just gonna leave off the for example.
That's fine.
The court, okay.
That's fine.
Okay? Yeah. Messager, leave off what? The court, leave off the for example, all of that. That doesn't make Messager, okay. The court. The question is how much data would be lost if the phone's been off and it stores a month of record? Messager, okay.
Yep.
Messager, and what was the for example? The court, for example, the phone is shut off February 15th after method 1. I don't know what that means.
Then on and off on February 21st.
The court, then on off February 21st and then 2019. Messager. Yeah, okay. The court, okay. Is the what is it? Cumulative data for the
Cumulative. Sorry.
cumulative. Yeah, thank you. I don't know.
Cumulative.
Cumulative data for the month in terms of total days or consecutive 30 days from the last power on and off. Well, that is a good question. It's the cumulative data of a month in terms of total days or consecutive 30 days. Oh, that is a good question. Sorry. Go ahead, McClellan.
Good question also. I think it's great.
The court, did method 1 extraction garnish knowledge seed data even though at the time the knowledge didn't, there's no end to it? That's Gull's comment. There's no finish.
Yeah.
It just says, did the method 1 extraction garnish knowledge seed data even though at the time the knowledge didn't?
So Gull is a lot like me. She's the literal part. She's getting very literal, and it's confusing her. So I'm okay with the first half. Just take off the even though. It's an incomplete thought, I suppose. It's an incomplete though, I suppose. Oh, yeah, it's an incomplete though, I suppose. Sorry.
The court, it's just an incomplete thought.
So we're dealing with their confusion and all this grammar, bad grammar, bad spelling, and big words.
The court, so just keep it out because I think it's completed without, assuming that's what it means, but it's kind of confusing. Can Snapchat videos and photos be deleted in knowledge C data with app usage? Messager, okay.
I'm okay with it.
Yeah, that's Messager, sorry. The court, can Snap cache pictures not exist depending on the way?
Whoa. You skipped a bunch. Go back. You're on 7. Go up. 6. You skipped 6.
Oh. Okay. The court, could a picture not be added to the Snap cache based on battery life?
Okay with that.
Messager, yeah. The court, could Snap cache pictures not exist depending on the way it was posed? Story versus.
I'm okay with that.
The court. Okay. How long does the iPhone 6S need to register floors climb?
How long does the app is the
How long does the iPhone S need to register floors climbed?
I'm okay with the question, but I don't understand it.
The court. I don't either. Miss Algier. I don't either. The court. So if we don't understand it, should it not be asked?
Probably, you think so.
The court. Okay, so
Probably correct. I mean,
the court. Does the data from the iPhone 6S tell us a start and end time for the 2-floor climb? Miss Algier, yeah.
it does, but that's an okay question.
The court. It does, but what?
It does. I'm okay with the question.
The court. Oh, okay.
Now to
The court. What happened to the Apple Health app data between 2/18/48 and 2/25/22? Is there a gap there? Miss Augier, it doesn't. It says like when it started and when it stopped, and then it started again. The court. Is that in which report is it? The case in case he asks me which report would that be?
Hmm.
I don't know. Would that me? Yeah, I think it meant to be B.
yeah, probably.
Miss Augier. 2. The court. Report 2. Miss Augier. Well, it's in both of them.
It's in both of them.
The court. Both of them, okay. So he would know. Miss Augier, yeah. The court. Okay, so what happened to the Apple Health app data between 2/18/48 and 2/25/22? Miss Augier, yeah.
I'm okay with it.
The court. Okay, lots of questions. Okay, so I'll be you'll be Cecil, please. Okay. Questions of the jury read by the court. Questions. Sergeant, in your first report, the photo depicting the Monon High Bridge with no one depicted in the still image at February 13, 2017 at 2:05. Let you get there.
What was the time again, Your Honor?
2:05, February 13, 2017.
Yes.
Okay, so the photo depicting the Monon High Bridge with no one depicted in the still image, did you ever locate or print this photo?
I did not.
Any follow-up, Mr. McClelland?
Nick? No, Your Honor.
The court. Ms. Augier? Ms. Augier, no. And next question. And in the first report, what are all the blank spaces under the event section on the timeline in your first report?
Those blank sections have to do with the battery. So I'm keeping track of the battery, trying to segregate it from other things that's going on. So that's why they are empty fields. I just kind of colored them.
Those blank sections to do with the battery. So I'm keeping, let's see.
If you're leaving this page, remember where it is.
Yeah, okay.
So we're on line 21 of whatever page this is. Page 86, I think. So the blank sections. Yep.
I think I know what this is. No, maybe not. Oh, here we go. That's this.
Yeah, this is cool. Like, I mean, I'm having fun. So even if it's just me and you talking and chat's enjoying it, I love all this.
Operating system modified. So he says, and in the first report, his answer, those blank sections have to do with the battery. So I'm keeping track of the battery, trying to segregate it from other things that's going on. So that's why they're empty fields. I just kind of colored them in. These are like all the same time, right? Well, kind of.
No. They're between the times they're talking about. So it's B and D. So each one of them is between 9:34 and 4:34.
Okay.
You see what I'm saying?
All right.
Like that number,
Mhm.
they stay there. So number 545 says February 14th, 9:34, and D is 4:34. Oh, is that just different time zones or something? Why is that exactly the same? See what I'm saying?
So B is UTC
That's okay.
and D is
Sorry.
yeah.
Eastern, yeah, we stand, Eastern. Did you say this before and I just didn't pay attention?
Yeah, it's okay.
Sorry, that's my fault.
No, it's fine. I was just
So we
like, I
should be
took
looking
a
at
bite. I thought you were going to talk about for a little bit longer, and
my
I
fault,
took a
my
bite
fault.
of it. No, that's what
No,
took me so long to answer.
it's D. D is Indiana East time zone. And UTC,
Mhm.
yeah, it's -5. It's -5 of, I'm sorry, I thought it was like a window in between this and that. So it's my fault.
It's okay. All right. So going back to
What are you eating?
rice. I made
Oh,
rice and
plain
chicken.
rice? Oh, okay.
No,
That's good.
no, like Spanish rice.
Oh, okay. Like with all the
Oh,
tomatoes and
shoot.
stuff.
Dang it.
Isn't there a name for that mix? Not hamburger helper. When you buy it and you just add it and make the rice.
No, I made like real rice.
Oh, okay.
Mhm.
Sorry. Okay. Yeah. We're
It's
on
okay.
this number 21.
Okay. So yeah, the court. Any follow up, Mr. McClellan?
Yes.
Follow up examination of First Sergeant Christopher Cecil. Questions by Mr. McClellan.
See, look at CCC. So the gray spots. Oh, this is great. See, now we're going to figure out. So we need to pay attention. Somebody in chat, pay attention to us what these color codes are for. See what I'm saying? The gray spots denote battery life usage from. So how are we doing this? Sorry.
So
Who's
you're
reading what?
asking, you're McClellan. So I'll be Cecil. That's
So
fine.
I'm Q.
Yes.
First Sergeant Cecil. So in those gray spots, are you using them to denote, I guess, separate the battery life usage from the other information?
Yes.
So you're not covering up information you found?
Correct.
Okay, nothing else, Judge.
Miss Auger. Then Miss Auger says, Your Honor, can I ask an omitted question about the first question? The court. Sure. Miss Auger, thank you. Okay, now we go follow-up examination of First Sergeant Christopher Cecil. Questions by Miss Auger. So I'll be Miss Auger. Okay. Sergeant Cecil, I hear you right that you testified you did not see the picture posted at 2:05?
No, I saw it. I just didn't print it.
Wait a minute. Okay, I will go
So
on.
we
Miss
found it.
Algier. Okay, I appall. Thank you. The witness, you're welcome. Okay, now we resume back to juror questions. Questions of the jury read by the court. And I'll be Gull. Sergeant, how does the phone receive iMessages, FaceTime calls, and telephone calls, but no SMS messages after 4:06 on February 13th and before 4:33 a.m. on February 14th without a signal via cell phone or cell tower or Wi-Fi connection?
I don't have an answer.
Oh, did I miss this in the notes
No,
of everyone?
no,
I feel like I don't
no.
remember this like being reported back. It was just so much. So
This is going to be the part where he goes out and checks Google to figure out stuff.
no,
Oh,
that was like the day I was there actually.
okay.
That's what's her name? Eldridge. Okay,
Oh, right.
the court. Okay, any follow up? Your question. Okay, oh, you're McClellan.
No, Your Honor.
Miss Algier, no. Okay, next question. Did you ever check to see if AT&T had any cell tower issues between 4:06 p.m. on February 13th and 4:33 a.m. on February 14th, 2017?
No.
The court. Mr. McClellan?
Mr. McClellan. No questions, Judge. Thank you.
Miss Algier? Yes. Okay, now this is Algier. I'll be Algier. Question. So this is like a follow-up examination. So, okay, Algier, that's not something you would have done. Is that right?
Correct, ma'am.
That's something you would have other teams of investigators look at.
Correct.
Thank you. Okay, back to juror questions. All right, read by Gull. Are you aware if Snapchat saves photos not updated to the story?
They don't.
Do they mean uploaded?
Not updated to the story. Are you aware Snapchat saves photos not updated to the story?
Okay, they don't. The court, Mr. McClellan.
No questions, Judge.
Miss Algier, yes. Okay, questions by Miss Algier. But you would expect a photo that was uploaded to Snapchat to be saved on the phone.
Correct.
Anything else? Miss Algier? No, thank you. Questions by the jury, read by the court. Okay, Gull. Do the pictures that get sent via Snapchat, not on a story, but to a friend, do those get saved anywhere?
That I don't know. This guy's clueless.
Okay. So that picture that Libby took at 2:05, how the F who took a screenshot of that photo? Do you recall? You know,
I
like
recall.
that supposedly got uploaded
I know.
to.
I remember even seeing her. It was one of Libby's friends, like another 14-year-old girl. Screenshot it. Almost positive. Check with chat, but I'm pretty sure they said that a a female friend of Libby's saw it and screenshot it before.
Okay.
How long do they stay on? I don't use Snapchat. How long
I
does
don't
a
either.
photo stay there?
I don't know, but it's
Anybody?
saying like I'm thinking like for Snapchat, like if you don't send it a story, does this still count down? Like, no, it's not going to give you a time like 8 minutes ago or whatever, right? Or 7 hours ago. Is it
Right,
like how
but
long did it?
listen,
Mm-hmm.
the girl screenshot it. There'll be a time on her because hers isn't a Snapchat. Hers will be a photo in her phone. She screenshot.
Yeah, I know that, but I guess where
Okay.
I'm trying to connect the dots here is if she sent the photo to and then like one person, right, through Snapchat, not on her story, right,
Oh,
and that person, clicks on the image, does it say 7 hours ago or whatever it
okay.
is, like if she goes back to it?
One sec, because I have no idea how Snapchat works. Do you take a photo and then choose who to send it to, or is it basically anybody who's your friend or whatever sees it?
No, I think you can send it to people. That's why, like, directly, you don't have to put it in a story. So like imagine, like, do you know how to use Facebook?
Yes.
Okay, so this would be like in my scenario, like what I'm trying to put together. Okay, we like the story would be similar to a post, right?
Hmm.
And the direct message would be just that, a direct message.
Oh, like Messenger. Yeah.
Yeah, like Messenger.
Whoa. Are we sure? Because also on Facebook, you can have like a story, like it be like a short, and then you can also just upload a photo in a put a
Okay.
comment to it.
Yeah.
They say not
I
on a
know what you're
story.
saying. I know what you're saying. I'm not even thinking about like the story scenario. I'm just trying to like separate between what everyone can see versus direct messages. So my question, like if it's a direct message, the way I interpret this is, based on the question, do pictures that get sent via Snapchat, not on a story, but to a friend, do those get saved anywhere? That I don't know. How do you not know this?
So I don't know either though because I never used Snapchat, so I'm not sure if how it works. I
No,
don't
no,
even
no,
know.
not you. Like, how does he not
No,
know?
no,
Like,
no.
he's an expert. He's
Uh,
supposed to be an expert, right? Like that.
I'm
What he said.
saying I have no idea because I can't even contemplate an answer to this because I'm not even sure how it works. So I can't tell you why I think he's dumb and doesn't know because I don't know. I'm not saying you're saying it's
No, I
me.
think we don't even have to go to an understanding of how it works. I think he is on the stand as an expert witness. He's
Yeah.
testifying to, the knowledge sea and everything that's in there. So I would think he would know the answer to these questions, unless they have the wrong
Well,
expert on the stand. you know?
no, no. They got just the right guy because they don't
Yeah,
want
that's true.
this is planned. If they really wanted it, they could get an excellent expert, but they handpicked this guy probably. He's a dope. Some expert. He said I don't know how many times. There's been like 10 questions and 7 of them he doesn't know.
Yeah, here's another one.
There's
I mean, I'll spare
that
everyone
I
the
don't
back
know.
and forth. The next question from the jury is the photos, I guess I'm trying to get at this clear my mind first, Sergeant. If the photos are uploaded to the story, do you know, are they saved to the phone?
That I don't know.
As opposed if they are sent to a friend via the other Snapchat avenue, not the story, do you know if those are saved to the phone?
They could be
They
cache, but
could.
I'm speculating here. Basically, that's I don't know.
Okay. So
Like,
here's my
oh
issue with this. This is crazy. Here's like
yeah,
reason 500 there's not enough evidence in this to convict Richard Allen, in my opinion. You got this dude that is the phone expert, and you're using the phone and Apple health data to determine a time of death. And this dude does not understand how Snapchat and other things function. Like, this is crazy to me.
And they're using all his other information when he can't answer these simple questions.
Yeah. I mean, because like that's like 205, and you got 207, and then you got what, 213. All of those are within an 8-minute variant from each other and a time frame. And that is like, if this is a felony murder, isn't it? Like felony murder, the kidnapping is on the bridge, felony murder, and you cannot answer like what the hell went on with this phone between 205 to 213. Like, who does she send this message to? Why isn't it in the phone? I don't know. It's just kind of crazy to me. Sorry, I'll get off my soapbox.
I would think that it was whoever follows Libby saw this and it disappears, right? And I just don't know. Are they trying to say that she only sent this to a few people?
I think the jury is trying to understand why it's not in the cache. Right. I think that's why they're like, yeah, I think their mind is open at this point, trying to look at an explanation as to why this, like, does this photo even exist? Right. And then like, go ahead.
Picture Libby, and like say it's like a personal photo of her that she wants to just send to a boy or like a friend. But I would say any other time they're just a photo like that on the bridge, you put it out and it goes to everyone that's your friend or whatever. And luckily this one girl, I guess, screenshot it.
Sergeant Cecil, I hear you right, that you testified you did not see the picture posted at 2:05. So he's like, he answers the question, no, I saw it, I didn't print it. Posted. So he's like, he didn't say, I didn't, like, I can't confirm this picture was posted or not, right? Like, that's not how he answers this question. He says, no, I saw it, I didn't print it.
So basically they can't find it. And that's another way of them saying, trust me, it exists. The one you found on the internet or whatever, it exists, but I didn't print it. But you have to trust me, I did see it back then, or whatever he's saying. He saw it, but he didn't print it up. That's another trust me, bro. I guess.
Another thing that is telling here, we could kind of put pieces to the report that has all those blank rows, right? Because of the excluded from public records written on the pages. Here, they also describe the description of the image. They describe the image. It's like said out loud. Like the image depicted. Didn't they say something like that?
I'll answer as Cecil. I don't know. I don't know anything. And eventually I'm going to have to go out and Google all this shit because I'm the dumbest expert they ever had. And it's by design.
Okay, here's what it says. 214-205. The photo depicting the Monon High Bridge with no one depicted in the image. Did you ever locate or print this photo? So that is like in one of those blank pages, like that would be a line on that report. 214-205. The photo depicting the Monon High Bridge with no one depicted in the image.
Well, there was a blank. Yeah, it was a blank photo. It was not a blank photo, but it wasn't of Abby on the bridge. It was just a bridge, empty bridge.
Yeah. You're right. Then why isn't that there? It's not on the exhibit list or that exhibit. Yeah, that's right. Because at 205 is the blank photo, and then 207, right, is the Abby one that they can't find. Right?
Right. So why can they find one and not the other? That's the whole. If one is there, shouldn't the second one be? Because the first one they have, then she did the exact same thing with a person in the picture. Ooh, so maybe honestly, maybe Libby chose that empty bridge can stay, and the other one has to disappear. Is that a choice in Snapchat? Like, can you have so pictures actually don't disappear?
I don't know. Well, I'm gonna comb through this and see if I can get a key, make a key to the colors. I think we'll be here all night.
Yeah, sure. Yeah, whatever you want.
Comb through this. No, it's okay. I'm just like, my mind's spinning right now. I probably shouldn't open this can of worms right now because it's like I have a hard time like now slowing down my mind here because I got a million things going through it right now.
I think you did 3 hours. You did 3 hours before I even came on. So yeah, I was.
Yeah.
I'm fresh.
Yeah,
I just made a coffee and I was fresh, ready to go. So why don't you plan something then? Why don't you plan something next time if you want to have a special guest like me?
Yeah. I think I want to go through this transcript more.
Sounds great.
Yes, I haven't yet.
I love doing it because we always stumble on stuff and learn stuff. So if the host would just be more prepared next time, I think this would be great.
Yeah.
I'm just kidding. Awesome.
Yeah, okay. I'm going on 4 hours now. I think it's time to shut it down. Getting tired. But I do appreciate you coming up on here. And again, it was fun.
It was fun. Yes.
Definitely a good ending. I was talking to myself for 2 hours first, or 3 hours. So, yeah.
Yeah. So next time, just plan ahead. No, I'm just kidding.
Well, you asked the question, Mister. No, I'm just kidding.
I know. I'm the looper. I definitely get stuck in those loops. So how about this? On Discord, we'll figure some stuff out before next time, and we'll need a safe word for when I get stuck in a loop. We'll need a safe word to kick me out. Because in the safe word will basically mean, hey, dummy, you sound like an idiot. And I can handle that. No, I do get stuck in those loops for sure.
It's not your fault. I'm the one too that was like, no, we're good. It was awesome. So thank you for joining. Okay. Thank you everyone for participating in the chat. I think a lot of people probably fell asleep.
It says 14 people, so. Oh. And Charles says there's always at least 10 more incognitos. So good night to everyone, and good night, lurkers, and
exactly.
I guess.
All right, take care, everyone. Thank you for joining. Thank you to the mods.
Bye.
All right.
Thank
bye.
You.
You think you got me figured out, reading comments like they count, drama feature empty, so truth ain't part of your life goals, all your screenshots and your claims, playing victim in your games. Why you always stirring up the top though? receipts that don't add up. Manufactured drama cup, overflowing with your lies. Time to cut you down to size. All your stories